Pronouncement of judgment. Item number 1.
In the proceedings of a tribunal, therefore, it can be seen that it is not a case of denial of opportunity or that, as alleged by the petitioner, there has been a violation of principle of natural justice. On this ground, the plea of the petitioner's regard fails. However, coming to the order in appeal dated 21/12/23, the Executive Committee had heard the matter in detail and upheld the order of tribunal. The said order was signed only by a single member of the Executive Committee, which is therefore rendered incompetent and in variance to Rule 31 of the Assam Meghalaya Autonomous District Constitutional Council Rule 51. The order in appeal, therefore, in absence of any authorization according to the rules of 51, the incomplete order dated 21/12/2023, being signed only by a single member, liable to set aside, and the appeal be remanded for reconsideration by the Executive Committee. According to facts and circumstances, the order soon set aside, remanded back to Executive for disposal according to law. However, it is further provided until further orders are passed and appeal on remand, serious course shall be maintained by the parties. The petition of the extent indicated above and disposed of.
Right.
Item number 2.
The observation has been viewed the fact that in spite of the submission of 3 inquiry reports, the impugn charge sheet had been issued 10 months thereafter based on definite charge or non-submission of the same. The incompetency of the charge sheet in this respect was thought to be repaired in hindsight by respondents to alter the same to one of delay by means of corrigendum will also not cure the basic defect and amount of clarity in the due process which cannot be allowed or condoned. Added to this is the fact that charges and statements made in support thereto clearly show the presence of a vigilance angle, which, as mandated, no CVC advice was sought. The reply to show cause, therefore, if indeed already filed a petitioner for disciplinary authority on a charge so free and redundant on a stated fact and circumstance of the case. According to view of the discussion made on above, the impugn charge sheet dated 22/4/25, corrigendum dated 5/8/25 being visited by incurable defects, the same may hereby set aside if watch leave the respondent to take any further action strictly in accordance with law. Is allowed to the extent or allowed dispose of. Yes.
Any mention?
May I please, Your Lordship? Your Lordship, I'd like to mention item number 34. We are still trying to resolve the matter, Your Lordship, in this matter.
What 34?
This is the rubber plantation, my lord, with the pollution board. My lord, we have revised the environment compensation into half. We're waiting for them to pay.
Pay?
Just take instructions on that, Your Lord.
2 weeks. Yes, as the matters in the process of settlement. Yes. Yes.
Your Lordship, I'd like to mention item number 45. We are in item number 45. The chief is no more, so we have to substitute.
You settling it, correct?
No, because we
had no intention of any.
No, what happened? Last time, where was adjourned?
So we have adjourned in the case that we will try to negotiate. We'll see the possibility for negotiation, but because the chief is in hostel since that time, there's till now.
When is the new chief coming?
No,
acting chief also.
No acting.
How can there be no acting?
After the chief expired, so
the council.
District Council have not yet approved.
It's not possible. They have an acting chief in the meantime, till such formal appointment is there.
We are waiting for the Sanad.
My Lord, if they are seeking more time, my Lord, kindly grant us stay, my Lord. At least there's no.
Stay on what, Mr.
My Lord, on all the orders. At least, my Lord, if we are allowed to continue.
Part on the road.
My Lord,
What is the matter?
if we are allowed to continue, either if the case is favored in our in
that case,
the
then
petitioner,
it
my
will
lord,
become
nobody
infructuous
faces loss,
in
my
that
lord.
case.
2 weeks, yes.
Kindly, my
If
lord.
they stay, they'll be infructuous, yes. Let them see. They had
There's no doubt about that.
The circumstances you have to appreciate also. Doesn't
Yes,
mean
my
that,
lord.
you know.
There's no doubt about it. My lord, but at least the timeline has been stretched overdue, my lord. Overdue, my lord.
2 weeks, yes.
Yeah, much more.
As the incumbent, that is the same Swara has expired recently. Yes. Yes.
Bless my lord.
Please, Your Lordship. Your Lordship, I beg to mention item number 44.
You've taken consent. You've taken consent.
No, Your Lordship. No.
Yeah, objection.
No, Your Lordship. 2 weeks time, Your Lordship.
Okay, 2 weeks, yes.
Deeply obliged, Your Lordship.
May I please, Your Lordship, item 43, my lord. I have informed my lord, Mr. Chanda also, my lord. Kindly after 2 weeks, my lord.
I'm for respondent number 6 and 7, Your Lordship.
My lord, deeply obliged, my lord.
Much obliged.
May I please, Your Lordship? I'm mentioning item number 27. I'm appearing on behalf of my Madam Sering Yange, Senior Conducting Counsel, as she is out of stations due to her personal difficulties. At the same time, her husband medical treatment, Your Lordship. In respondent number 1 and 2.
Yes, 2 weeks.
Obliged.
Obliged.
May it please, Your Lordship.
Yes.
Lordship, I beg to mention item number 35, my lord. My lord, I pray for 2 weeks' time.
No objection, Your Lordship.
Otherwise, you would have to take time. 35.
Lordship.
Okay, 2 weeks request also, sir.
Deeply obliged.
Item number 3.
Please, Your Lordship. Lordship, I'm praying if this matter may be listed at the end of the board, Lordship.
Number 3. Looking for notice, correct?
Lordship.
Then, yes. Now, you don't ask me an interim prayer. Is there interim prayer?
No, Your Lordship.
Is there any interim prayer, Mr. Zinja?
Lordship, I just received a brief, my lord, just now.
Oh, this is for promotion and pay scale.
Lordship.
Not.
Yes, heard MS S. Khatun, correct?
Lordship.
Let consideration issue notice. Mr. Jain Ranja
In for spot number 1, my lord.
is present, except on behalf of spot number 1. Notice issued spot number 2 within 3 days. Just over 2 weeks for instructions every days.
Obliged, my lord.
Obliged, Lordship.
Item number 4.
Yes.
May it please, Lordship. Your Lordship, the present petition is being filed seeking protection from this Honourable Court against the constitutional right which is available to the petitioner for right to property, my lord, under the Constitution. My lord, we are aggrieved by the renewed patta which is issued by the GHDC, my lord, insofar as the...
Where's the JDC?
He's coming, Your Lordship.
Oh, he's here. Yes, where's the impugn order?
My lord, if your lordship could kindly have an extra 6, we are the petitioner is aggrieved by this renewed patta, my lord. Initially, my lord, the original patta is at annexure 3, your lordship, page 43, my lord. Page 43, annexure 3. The type copy is at page 47 onwards. If your lordship would kindly have page 50, your lordship would see the area, the schedule.
Page
50. It starts from page 43 onwards. This is the original patta, my lord.
43.
I have
46.
Yes, my lord. I have enclosed the type copy. It starts from page 47, my lord. The type copy.
Second class homestead.
Yes, my lord. The schedule is at page 50.
At page?
So, your lord, initially this original patta was of this area, which is equivalent to 15 lessa, my lord. But however, the GHDC, my lord, without following due process of law, has renewed the patta, and in the renewed patta, my lord, there's an increase of land, the area, my lord.
See, where's the schedule? Where is the area of the land mentioned?
Page 50, my lord.
There's Bhiga Katha Lechas.
Yes, lord.
15 Lechas.
The area, table number
Total
3.
rate is 15 Lechas, you say. Yeah, now what happened after that? This is which date, this schedule?
I'm sorry, lordship.
When was this patta dated when?
This patta is dated on 2009, lordship.
2009.
Yes, lordship. My lord, can kindly have annexure 6 now, my lord. This is after the mutation have been done by the respondent.
Now you are the owner, you say you're in possession 15 Lechas. This is whose patta?
This is the patta of the respondent, my lord.
Okay.
So I am the neighbor. My lord, of the respondent. Because of the illegal issuance of the patta by the GHDC, my lord, my land has been encroached, my lord. So we are aggrieved by such an arbitrary and fraudulent manner in which the GHDC has
File a suit also.
Yes, lordship, we have filed a suit, but being aggrieved by that suit, my lord.
We agree. Who filed a suit?
The petitioner, my lord, they have filed a suit before the executive magistrate at Tura.
You are the Sanjukta Pal.
Yes, my lord.
In the suit, Kanan Pal, who's?
Kanan Pal is my mother, my lord. She's an aged woman, lordship.
You drew the suit?
Yes, lordship.
Why?
So this being dissatisfied with this suit, my lord, we have appeared before this Honorable Court by way of criminal revision petition. It's still under
criminal revision.
Yes, lordship.
Why?
My lord, because there's some erroneous. I mean, by the way that the proceeding was conducted at the
criminal revision
petition, my lord.
Where's the criminal angle?
So, my lord, because my land has been encroached, your lordship, without we have which yes, my lord, we have challenged under my rightful piece.
No, where's impugn order? You say where's impugn patta?
The impugn patta is at annexure 6, your lordship.
Page?
This page 56.
Issued when?
This is issued in 2016, my lord. 15 March 2016.
Now you come now.
Yes.
What was proceeding for the revenue authorities in GHDC?
No, my lord, we have verbally approached the GHDC.
That doesn't work. See, for cancellation of patta, now this Assam Land Regulation is applicable to GHDC. So now 2009 you had 15 Lechas. Now you say that this your neighbors the land increased.
Yes, your lordship.
And over your lands included in their patta.
Yes, my lord.
How are you filing a writ now?
So we are aggrieved by such an arbitrary procedure.
How arbitrary? Now 10 years you found it arbitrary today.
Well, let notice. I only pray.
What do we notice?
Here, my lord, an alternative remedy is available. Now, if the alternative remedy is available, my lord, then the petitioner can they approach this honorable court?
No, but GHDC. Where are you saying where the increase in this schedule 64?
Yes, my lord. Kindly have
6 Lechas. This is your patta.
This is the patta of my neighbors, my lord.
But 6 Lechas only. Where's the increase?
This, my lord, I mean, your lordship, this is the traditional measurement of land, which is equivalent to 26 less, my lord.
See, this is out here. Shares one katha 6 Lechas.
Yes, my lord.
So that means they have land how much before?
My land is 15 less, my lord. This is the respondent. I mean,
I understand. We understand. The thing is that now, what are you challenging? You're saying that what is the land? What is the area of the? Where's the old patta of the neighbors? You have it here. To show the land suddenly increased. Just to let the court understand. You see, in plain districts, Garhwil's Assam is given like that Bhiga, Katha and Lecha.
Yes, sir.
Right?
Gotcha.
Yes. So show where the land, where's the earlier patta of your neighbor, where it's not, out here shows 1 Bhiga, 6 lechas, or 1 katha 6 lechas.
My lord, I've already taken your lordship to Annexure 3, and Annexure 3 in schedule.
That's your patta.
No, this is my my neighbor original patta, my lord.
15 lechas.
Yes. So, and the Annexure 6 is the renewed patta which is issued by the GHDC. So we agree because of this renewal of the renewal patta, my lord. So such increase of land could not have been ascertained, my lord, because neither there was any sale, because when in 2009 when the area was of 15 lessa, how come in 2016, my lord, there would be an increase of land when only there was a mutation towards it, my lord, but there was never any extension of land.
See, now, just to see the order renewal. Yes, Mr. D.
Well, if the alternative remedy is available
After 10 years.
Yes, my lord. And second,
Why they have come by it? You understand? To avoid all this delay and everything, to circumvent it. If someone 16 years sleeping till now.
But while we have,
I'll take instruction that.
What instructions you'll take?
Here, my lord, what is the allegation? Is this, my lord, how his neighbor land has increased, whether there was demarcation or not? As per the RTI, that they
there
have
was no demarcation, proper demarcation. Even, my lord, till the current position is as such, my lord, that the private respondent, they has started to construct an RCC building.
No, that's why you woke up.
Encroaching in my land, my lord.
That's why you woke up suddenly. Assam land law. Assam land law. Have you quoted the provisions of this Assam land regulation? Are you aware of it?
Yes, lordship, I have.
Then, what measures you need to take under the? Now this was in 54. Assam land is adopted by the District Council, ECDC. Prepare your case well.
Yes.
See, the thing is that if you have an objection to patta, it goes straight to revenue member. Correct. And if there's some discrepancy or something wrong, they go for remeasurement. There's a question of adjacent patta you have. Correct. And patta is not a document of title. Remember that. It's just a record of rights. Yes. Anyway, you do your research. Yes, Mr. You just take instruction.
I'll take instruction, my lord.
I don't think you have not made one application before the revenue authorities also.
No, Lordship, but by way of an RTI, we have approached.
RTI is what?
True, Lordship.
You're lucky you're not dismissing this right here and then. Hurt Mr. Kambujai, right?
Yes, Lordship.
Issue notice.
Respondent 5 to 8.
The SD is present, accepted to be a 1 to 4 of notice. Goes to go to respond of 5 to 8 and 9 within 3 days. This up to 2 weeks.
Highly obliged, Lordship.
Item number 5.
May it please, Your Lordship. Lordship, this is the VEC matter from Batabaris in RD block. Now, Your Lordship, this is a Rajabala VEC. Previously, it falls under the Silsilas in RD block. And Your Lordship, it was bifurcated from Silsila, and there's another block which was formed. That is the Batabari block. Your Lordship, upon formation of the Batabari block, there's a bundle of writ petitions which was filed before Your Lordship. And it was disposed on 30th April 2025. Now, Lordship, with this direction, there has been block VECs being bifurcated and required to conduct and hold election to the VEC. So now, Your Lordship, in compliance of the order dated 30 April 2025, it's at page number 11, Your Lordship, Annexure 2, in the main petition. Your Lordship, direction was given by Your Lordship is that to hold election to those already been bifurcated and the remaining to be completed within a period of 2 months. Your Lordship, the state respondent, in compliance of the order, they have made notification. They published notification which is Annexure 3, dated 31st October 2025. Your Lordship, here in certain conditions were laid as to how the conduct of the election to the VEC should be conducted. Now, Your Lordship, I have impugned this notification, whereby it has stated that the schedule of the election should be held in for the 3 villages so that a fresh VEC may be constituted. Your Lordship, Rajabala, for Rajabala VEC, Your Lordship, the date of nomination has been scheduled, and even the poll and the election has already been conducted. Now, Lordship, on the day of the election, when it was conducted on the 17th,
17th?
Yes, Your Lordship.
Okay.
It was last week, Lordship, November. Then there has been some certain anomalies, Your Lordship, and irregularities, whereby the terms and conditions are not fulfilled in accordance with the notification. Your Lordship, in one of the notification whereby has been laid down, especially number 4, 5, 6, Your Lordship, may I read, that all candidates should not be any government, private employed person, that the office of the undersigned reserve the right to cancel, reschedule the notification without prior notice. Candidate job card holder can cast their vote, but 1 vote and 1 job card will be strictly followed. And candidate job card holder must produce the original job card at the time of voting. Now, Your Lordship, what happened, the petitioner here, and I am a contesting candidate to the post of the secretary, to the Rajabala VEC. Your Lordship, upon the day of voting day, Your Lordship, and upon counting of the election, we have we saw that there are certain anomalies whereby the condition has not been fulfilled. There has been multiple job card holders, Your Lordship,
so you
from
mean
other
to say
VEC.
no proper verification was done?
Yes,
the
Your
elections
Lordship.
were held.
Yes, Your Lordship.
Then what is what is the normal recourse you take that time? You made a complaint for BDO.
Your Lordship,
What is it?
I did not make a complaint yet, Your Lordship, but I have approached before Your Lordship because in the event of the constitution
How will
of
the court now have a roving inquiry, go out there and see whether these voters are verified or not?
Your Lordship, that because of the urgency that they may publish, the state respondent may publish notification now, and in the event of their constitution of the new VEC, then there will be another multiple litigation, Your Lordship. So, Your Lordship, my humble prayer approaching before Your Lordship is that proper verification be conducted again by the BDO.
How proper verification elections already held? Was proper verification carried out? Mr. Shla, you get instructions?
May it please Your Lordship.
Have you got instructions?
Lordship, in fact, I would like to raise the maintainability of the writ petition.
Yes.
Lordship, the allegation, Your Lordship, is that there are dual job card holders, Your Lordship. There are no material proof, Your Lordship. It's in the writ petition. Can you have
your main grievance that there are multiple job card holders?
Lordship,
Yes,
from other VECs as well, Your Lordship.
Can you have page 6, paragraph 8 of the writ petition, Your Lordship? Lordship, kindly come to page 5 first at para 7. What are the allegation, Your Lordship, at para 7?
Yes.
Violation of the term laid down in serial number 3 to serial
7.
Paragraph 7, Your Lordship, at page 5
Yes.
of the writ petition. What are the allegation, Your Lordship? Clear violation of the terms and condition laid down in serial number 3 to serial 7.
Yes.
Then, Lordship, can you have a para A?
Yes.
Holding a dual job card from other BECs. Where are the materials, Your
Spot
Lordship?
number 6, he's from where?
Lordship, so far as to the instruction received, they are from Rajabala.
Then?
But the casting of the votes, Your Lordship, like I said, because Your Lordship, as
Where
per
are the materials,
as
Your
per the
Lordship?
order, it can be cleared, Your Lordship. But there has been some, Your Lordship, because of the difficulty of arranging of the entire votes with respect to the VEC, Your Lordship. Because there are still other VEC which has not yet been constituted and no election has been held so far, Your Lordship, with
Now,
respect to
where have you
Batabari
shown that
Senadi
in
block.
Violation of MG and RES, GS. Where is that?
Where are the materials, Your Lordship?
Your Lordship, due to the urgency that notification should be published, I have filed an accompany application, Your Lordship, for stay. May I be allowed to bring on other materials if required?
How can you ask for stay, Mr. Yudungdo?
Your Lordship,
Very compelling circumstances if you file a writ petition. You see, you
I
come to
understand,
the
Your
court,
Lordship.
it's a last recourse.
yes.
It's not a question of, just to settle scores with some other political rival.
No,
That you
Lordship,
come
it's
and
not
try
matter
to,
of-
now if they have won the elections fair and square, now then you're trying to settle scores without any tangible materials being put on record.
Lordship, the material I have collected, Your Lordship, but I may not be able to.
Kerala Hassan, number 6.
I'm for the private respondent, my lord, the candidate who won the election, my lord. Now the petitioner here, she secured 24 votes, my lord, and the my client, my lord, Meera Rani Das, she secured 136, my lord. So not this frivolous petition, my
But
lord.
Lordship, I have been.
So we'll impose cost.
No, Your Lordship.
We'll get instructions, and if it proves otherwise, then be prepared to have pretty heavy costs. Heard Mr. S.R. Lingo.
Your Lordship, in a while, may I be allowed to bring.
Petitioner, Mr. N.D. Shulai is present. We have response number 1 to 5. No more notice. Mr. N.D. Shulai, the AG, with so and so, is present. As such, no further notice required on these respondents. Ms. S.K. Hassan, who's present in court, has submitted that he would be representing respondent number 6, the successful candidate in the VC elections. Stop.
Your Lordship, both the
grievance
secretary
of
and the
Mr. S.R.
president.
Lingo is that they, pursuant to order of this court, they did 30/04/2025 elections across the bifurcated blocks to respective village employment councils have since been held. The Telecom submits that for the incident VEC, the election incident VEC concerns Rajabala, which is shown at column but is shown at number 3 in the notification for election the 31st October 2025. They submitted that no proper verification was carried out before the elections were held, and moreover, spot number 6 also, who is the winning candidate, her name is reflected in a different household job card stuff. He therefore prays that the elections be the result of elections be not declared, be not notified. So, the next paragraph. In reply,
Your Lordship, in the order for constitution of the new VEC.
Mr. N.D. Shulai and EG has vehemently opposed the petition and submits that no materials have been placed for consideration, or are the allegations backed by any substance. Stop. He submits that all allegations cannot be the foundation for seeking any interim relief. Next paragraph, Ms. S.K. Hassan, who is present, we have number 6, submits that the entire writ petition is frivolous, inasmuch the writ petitioner, who was the contesting candidate, had secured 24 votes as opposed to 136 of the winning candidate. Therefore submits that the writ petition deserves no consideration and should be dismissed at the threshold itself. Therefore, the council of the parties also examined the materials on record is correct as submitted by Learned EAG that the bare petition has been filed, wherein no materials have been annexed, apart from impugning the notification dated 31st October 2025. In these circumstances, at this stage, this court finds the petition incompetent and the same is dismissed accordingly. However, liberty to the petitioner to file afresh if the said allegations can be substantiated in a proper and cogent manner. Yes.
Item number 6.
Yes, where
my lord has heard the matter at length. This matter. In the meantime, one of the petitioner passed away, my lord. I filed a substitution application. Item number 11 of the day's course.
No, WPC number. Just kindly give the petition number.
WPC number, my lord, 158. 158. The mother passed away, therefore the daughter came forward to substitute. But the father passed away, I'm sorry.
Father?
The father passed away and the daughter.
Petitioner number 7.
Petition number 7.
Elipon Nongplang.
Right.
She is the daughter.
She is the daughter of the late father.
Who's on this is an application seeking of substitution of the WC 158 of Miss Case number 293 of 2025 in WC number 158 of 2025. This is an application for substitution of the petition number 7.
Number 7, madam.
Namely late
Station Wajri.
Station Wajri, who expired on 23rd of this pendency petition by the present applicant, namely
Elipon Nongplang,
who is stated to be the daughter of the deceased, petition number 6. Stop. Like for the same objected to by the counsel with the respondents. Accordingly, the name of Elipon Nongplang, applicant, shall be entered in the course title in place of the petition number 6.
Number 7.
Number?
Number 7.
Petition number 7. But since expired, yes. In this case, is allowed and disposed of. In the main case registry, ready to make correction in the course title and view the order passed in this case number 293/2025. Anything else?
But from my side, my land.
Any materials you want to give? Over. What? Yes, what is this? Today? Yes, MSS Laru. On behalf of respondents number? State respondents has also filed notes on submissions, or is a list of dates? Synopsis of argument. The same is taken on record. Yes. This for East Castle's separate rebuy spirit. Sure about that? What about the other annexure? You have replaced that?
That is stands replaced, Lordship allow.
That's replaced?
Yes.
Are you created enough confusion with these matters? But according to hearings concluded, judgment reserved. Yes.
Item 13.
Lordship, item number 13 and 14 are connected matter. Lordship, in fact, appeal has been decided on 1911. Lordship.
We'll close them.
Lordship.
Yes, Mr. S. Chanda submits that in view of the order upon the division bench, nothing is left for consideration in instant matters.
Lordship.
Only these two matters stand closed.
Lordship.
You're successful, right?
Lordship, what has happened is in the appeal, Lordship, there is a direction for conducting a joint inquiry, Lordship, and thereafter to be heard, all the parties to be heard, Lordship. That is the order.
Suffice, my lord.
15.
Obliged.
My lord.
Please, Your Lordship. Lordship, we have just received a status report regarding the impleaded petitioner, impleaded respondent, Your Lordship. Lordship.
Yes.
We'll file our service affidavit, Your Lordship.
What about affidavit?
We have filed, Your Lordship.
MS Imran submits that status of service has been received with regard to number 3. Property pay forms allowed 1 week's time to file affidavit indicating service.
Lordship.
Yes, thereafter on so on.
Much obliged, Your Lordship.
16.
Affidavit
You
filed.
file, madam.
My lord,
Yes, Mr. Mia.
they have filed affidavit and they objected that this petition doesn't come under this jurisdiction. They filed under section 42, but my lord, section 42 doesn't attract section 11, Your Lordship.
Where's the affidavit?
Primarily, we've taken 2 objections, my lord. One is in para 4 with regard to section 42.
Your Lordship, yes, they objected. 2 objections is there.
And second objection in para 12, my lord.
That work has not been executed, but I am saying that work have been executed, my lord. This is the dispute, Your Lordship. I am saying that work executed, but they are saying not executed. This is the dispute. Then now who will decide, Your Lordship? So arbitrator will decide that work has been executed or not, Your Lordship.
How can one arbitrate this stage? Who's going to determine whether you finish the work or not? Who's the conciliator? DRB? Who's the...
My lord, so kindly see page 11 of our affidavit, my lord.
See, what if you put it in your application, Dr. Mozika? Read at page
So there's
3.
some typo. I've seen that.
You can't put a statute and make a...
It's true, my lord.
And not 22 subsequent applications.
This 22 is, I don't know, copy paste, some mistake. All subsequent applications arising out of the agreement and that will.
Now, the situation is that you already been paid also.
No, Your
Lordship. The amount that they paid, 6 crores or 6,64,000.
But here actually what happened, my lord? Work was awarded to them. Halfway, they stopped the work, my lord, and we terminated the contract. Then they went to High Court, my lord. This is...
My lord, they have filed one...
No, arbitrators appointed.
Yeah, appointed. They went to Kohima bench of Guwahati High Court, my lord. Arbitrator was appointed. Arbitrator published his award. 18 lakh rupees awarded in their favor, 12 lakh rupees in favor of Union of India. Balance 6 lakh we have already paid. That is subject matter of execution petition pending before the Ceylon court, my lord. Now, in the meantime, after arbitration was completed, my lord, they came and offered to resume the work, to complete the remaining part of work, my lord. So they restarted the work. Now again, even before completing the work, my lord, they are again seeking appointment of
So who's going to determine whether they've completed the work or the work?
Kindly see.
What is the
they cannot.
agreement?
Page 11, lots of kindly see, my lord. Page 11 of the affidavit.
Yeah.
But this is a letter of 4th April 25 to them. Para 2 completion certificate submitted by you above refer letter has not been considered by those officers complete road work. Schedule has not yet been started on ground. Completion certificate will be issued on the execution of all the quantities catered in the subject work. In view of that, you are requested to start the road work immediately and complete all balance work before.
My lord, please may kindly page number 45 of my petition, my lord.
No, 1 second. How you replied this letter?
I have many replied. Yes, Your Lordship. I have sent them notice also that I already executed the work. So,
No, who to determine? Sitting here, how do we know whether he finished the work or not?
my lord, they gave me one report that is page 45, my lord, in my petition, my lord.
See, Mr. Dr. Mazika, all disputed facts, how would we determine here whether he finished or not?
My lord, it is their petition, my lord, and we are saying that they have not completed the work till date, my lord, and they cannot invoke arbitration, and that is on affidavit, my lord.
My lord, last time two official came and they verified that that is belongs to them only. They signed. Their signature is there, Your Lordship. Page 45, my lord.
Oh, get the work measured then. Can you order an 11th application? It's only for one arbitrator. How can you order for supplemental proceedings?
And secondly, they have to go to Koyama bench, my lord.
Ah.
No, my lord, because
swiping and choosing.
My lord, this is a parallel jurisdiction. This matter comes under parallel jurisdiction.
Your one you've chosen.
Agreement.
One code, you bound by that.
My lord, agreement executed here in Shillong.
Doesn't matter. If you know it's parallel jurisdiction, now you've chosen.
But my lord, this section 11 doesn't come under section 42, my lord.
Forget section 42 for the time being. The thing is that now to ascertain whether you finish your work or not, who will ascertain that?
My lord, they...
45 where? Page 45 what do you say?
Yes, they verified, my lord. That is section, page number 45, my lord. They verified. They mentioned there.
Where they mentioned?
The total work done rupees 1,28,94,200, my lord. Amount as per set 1,50,00,000, my lord. So now 21,70,000.
No, okay, fine. Whether you finished the whole work or not.
Yes, Your Lordship. We done more than that money,
where
my
is
lord.
that you completed the work and it's been handed over?
Yes, this is the report, my lord.
Accepted as satisfactory by the requiring authority. Where is it?
Yes, my lord. This work.
This is what the statement of variation of the schedule. Correct.
Yes, Your Lordship. Yes. So schedule is like the amount. The agreement was.
This dated. What is this certificate?
My lord, the total amount quoted by the lowest bidder was 1,28,94,200, my lord. But I have done, my lord, 1,50,00,000. I already spent 1,50,00,000, my lord. So 10% variation is there.
Who know where is the certificate showing you completed your work? They are denying it.
But they have given me this letter, my
What
lord.
is this?
This is the variation, your lord.
So where's the date? After 4th April.
Annexure. Annexure 4, my lord. That is 24/5/2025. Copy of notice dated and.
In the new agreement, arbitration clause is there.
No, your lord.
Then
the same agreement is there.
There's no arbitration clause in the revised or whatever. When you see what happens, a very strange case.
It's a very strange case.
It's a very strange case because arbitrators are appointed in the first instance.
What published?
He adjudicated, awarded you and both of you, and then the amount was received from 6 lakhs. Then again the work awarded to him. How is work re-awarded to him? Number one. Number two, now there's no arbitration clause in there's no new agreement signed.
No new agreement signed.
Then,
my lord, after second RR, there have been a dispute. They have filed a KBIT petition to the Nagaland bench, and after that we filed the section 11, your lordship, there. Then again I was about to terminate, my lord, but again they gave me the work. So I have finished the work and I have executed the work. Then they are not paying me, so that's why I am here.
So then we'll send arbitrator, see whether there's any dispute or not.
My lord, the difficulty, my lord, the road work is not, which is a part of the contract, my
see,
lord.
we are not there. The thing is that how is this court to understand his submission that is complete.
That was joint
Your
site
submission-
inspection, my lord.
Report is there, my lord. I have done 1 crore 50 lakhs.
But that doesn't indicate anywhere the
And
road is
10% variation is there. 10% is 1 crore 20 lakh. Is 10 lakh
See,
is
Mr.
there.
Mia, I don't make the submissions. You can make submission before the arbitrator with regard to the value of your claim.
Yes,
The
your
only thing you
lordship.
satisfy the court is that there is an arbitration agreement and there is a dispute
Yes.
with regard to, and the dispute arises mostly when the work is complete.
Yes, your lordship.
Correct? When it comes to settling of bills.
Yes, your
when you
lordship.
raise your claims.
Yes, your
Now in your case, they even dispute the very fact that you started the work again. Then
the work already have been executed, my lord.
That's a what. That's
File an
what.
affidavit. Let him file an affidavit, my lord.
File a
That he has
counter.
completed the work, my lord.
File after you complete the work.
Nothing is there to file, your lordship, because they are objecting
file-
just.
File an affidavit that he's
And after
completed
it's
the
been
work.
filed by the union, stop Mr. Mia to file a rejoinder in view of the fact that they are conflicting statements with regard to whether the said work has been completed or not. Yes.
My lord, affidavit with photographs of the road he has completed, my lord.
Whatever, let him. It's up to him.
17.
Just after 2 weeks, you file affidavit. You have to show that it's a dispute. Otherwise,
May it please your lordship. Your lordship, as per the last order, our affidavit was supposed to be on board. Your
Yes.
lordship, I apologize that we've not been able to file the affidavit because the respondent number 1 here, your lordship, she has retired.
doesn't
So in
matter. Then
order
you have
to
to
show
appear
what-
personally.
In order to show what steps were taken, your lordship, she cannot access the file. So I'm
Cannot?
just access the files, your lordship, because she's retired.
Well, it is a contempt application.
Yes, your lordship.
Then, who's the other one? Did you have to appear in person then to answer?
Your lordship,
Why
here
they have not
respondent
complied?
number 2 service is also not complete on
No,
respondent
we have
number 2.
check it
so-
because still waiting. We have written a letter to the
Give
postman.
you 1 week's time, you file affidavit. Otherwise, we'd have to appear personally.
Your lordship,
She
if
retired when?
in July this year, your lordship.
Then? When was the contemptuous act?
Contempt was on 9/9/2024. At the time when she was
Order was passed, your lordship.
that time she was
For graduation.
Yes, your lordship.
regularization and to release the pension.
So, your lordship, I'm praying that fresh steps may be taken on respondent number 2, your lordship, so that we can at least.
That there's no problem.
Yes, sir. It is submitted by letter MSZ non-country appearing for the. In contempt case, you don't appear as a government advocate.
Yes, your
It's
lordship.
always by personal engagement. Versus a person that yes, MSZ Learned Council for respondent 1 submits that as the respondent are retired, some more time is required for to access the files. You have to file the affidavit stuff. She further submits that on respondent number 2, the service is not yet complete.
Yes, your lordship.
And review the matter. This matter for 2 weeks for affidavit and for fresh steps. For 2 weeks stop petitioner and then we like to take fresh steps on the respondent number 2
Lordship.
within 3 days.
Lordship.
Obliged, your lordship.
Must be lordship.
18.
Lordship, we have filed the affidavit.
Received, Lordship. Pray, Lordship, 1 week's time I can file my rejoinder, Lordship.
How much time?
Just 1 week's time, Lordship.
1 week's time? Yes. Mr. Archival prays that please for 1 week's time to file counter to a rejoinder the affidavit filed by the MCL or say this one.
MECL.
By the MECL respondent. Praise the Lord.
Obliged.
Lordship.
19.
Yes, also.
File Lordship. We have received the affidavit, Your Lordship. We want to file a rejoinder, Your Lordship.
For rejoinder?
Yes, sir. Because they have contradicted something, so.
2 weeks time has been allowed for rejoinders. Thereafter.
File.
20.
Lordship, in this matter, they're supposed to file the objection, Lordship. But Lordship, this is the 8th time, Lordship, they are seeking for time.
What objection is that?
respondents.
What's the case about?
This is that the post of constable.
We'll dispose it of Mr. Snaitam. Yes.
Allowed him to file
the correct. What is the matter regarding?
Yes, my lord.
Constable.
Yes, sir. We'll dispose it of.
Yes, your lordship let to file the objection, your lordship.
You see, you can't take the court for a ride. If you want to play around, you play around with what's the convention here. Just at your convenience doesn't mean the court will have to bend over backwards. You'll pay cost. You pick up 10,000 and allowed to file an objection.
May place it at end of the board, lordship, senior counsel.
No, not end of the board or top of the list. Really, Mr. Snaitam. It's the 8th time you've asked me.
No, this is my affidavit, my lord. I have not been able to file.
You want to file affidavit?
No, your lordship. It's for the affidavit.
Oh, not for him.
No,
it's
only
sorry.
8th time, my lord.
The 8th time asking?
Yes, lordship.
Because initially it was on at that stage, my lord, since we raised objection.
But receive. Where's the instructions? We'll go by instructions. We'll dispose of.
Yes, ma'am.
We thought that they were objective.
In fact, an earlier order passed by this honorable court, my lord.
Yes, show instructions.
This was.
Yes. You got the file with you.
Lordship. Lordship, may have it under the board, lordship, senior counsel.
Where is he in Delhi?
He know he's here, lordship.
What is this judgment?
The judgments may not be relevant because the earlier order is there passed by lordship.
Dr. Mozika submits that no appeal will be necessary as the same on a point of jurisdiction only. He has submitted a communication dated 9 September 2025 containing instructions received from the respondents, as also a judgment of this court rendered in judgment of this court dated 23/6/2025 rendered in jurisdiction of 2/4/6/2025. So, will they have it after 2 days? You just give a copy of instructions. Yes. Yes. Material will be supplied to the counsel petitioner is after 2 days.
21.
Yes.
Lordship, I pray for further 2 weeks' time to file affidavit. He to prepare yours.
Prepare what? What's the matter about?
It's a reconstitution of the managing committee, lordship.
Of the?
Reconstitution of the managing committee, lordship.
Is there a managing committee in place now or?
Yes, lordship.
In Shillong? The matter?
Yes, lordship. Lumdingri.
Who's going for the state? Nobody?
Jendran Jai, lordship.
Kipi Barachaji?
Yes, lordship. 21.
Oh, my apologies, my lord. My humble apologies. My lord, we received instructions, we'll pray for some time.
1 week?
I'll pray for 2 weeks.
2 weeks for the time is prayed, but response allowed. Expect next day the FG to be on board. Yes.
22.
May please your lordship, the respondent number 5 is supposed to file the affidavit. This case.
The lordship has to get some more time, lordship. File my affidavit.
What's the matter about?
This is regarding that Sardar of Mokanrao.
May I please, one submission, your lordship's here. A complaint has been made by some of the complainants, my lord. Those who have to ought to be made a party in it. Because the impeached letter, my lord, was issued and on receipt of the complaint filed by the.
Never made the party. Why?
No, my lord.
We have not made the party.
Why?
Kisur ki pajba Mokanrao and Maulen, my lord. Your lordship, can you have page 26? No, prior to this, a complaint was placed before the executive committee. Your lordship, if I may allow to place the complaint.
How many complainants are there?
Lordship, I think it is a conglomeration of all the residents. They claim themselves as a Sor Upajba Mokunre Mauland, represented by P. Wankar, N. Shilla, and E. Mansong.
Why no meet party?
In that case, we pray to allow. We will amend.
Just on the when the matter is taken up, you won't file affidavit. We have the same.
Yes, Your Lordship. I need some more time, Your Lordship.
When on behalf of MS Sunso, on behalf of one number 5, please for further 2 weeks time to file affidavit. Next paragraph, Mr. C. Sangma, however, has raised objection to the reputation on account of necessary parties not being implemented as party respondents. Next, Mr. Kibi Khalindo, please allow some time to examine as to whether
to implement
further parties will be implemented. Accordingly, this is a matter after 2 weeks before the orders.
Which you?
23.
Please, Your Lordship. By Your Lordship's order dated 4th of November, we were directed to file an affidavit indicating the status of service. I apologize, the petitioner has not been able to travel from Garo Hills. We may be given about 2 weeks' time. We've seen the status report, it's already been served in the private respondents.
What's the matter about?
Nokma dispute.
Where's the private respondent? Only 6 only? Or 2 of them?
For 1 to 3 minutes. 4, 5 and 6.
4, 5 and 6. They are
private
respondents. 4, 5 and 6.
The status shows that it's already been delivered. We just have to file a affidavit.
Yes. Mr. S.N. Repraise for 2 weeks time to enable the obtain status of service upon the respondents 4, 5 and 6 and to file necessary affidavit.
Gotcha. Obliged.
Accordingly,
24.
We have for the state response, number 1 to 5.
Number 6, served.
Yes, Your Lordship.
Served.
Service is complete on 24th October.
Where's your report? You have to
Your Lordship.
Upwards note the ED cards not received back.
Your Lordship, as per our report, it has been
Where's the report?
Your Lordship, I pray for liberty to file an affidavit of service.
Mr. Easing, the council submits that respondent number 6 has been served. He prays for the 1 week's time to file after indicating service on the respondent.
Well, we are awaiting instructions for that.
Ms. Kiba, she also prays that without further time on behalf of response number 1 to 5.
1 to 5 minutes.
For filing affidavit, just about 2 weeks.
All right,
for the orders, yeah.
25.
These are transport corporation matters for release of retirement benefits. We have instructions may be granted about 5 months time.
5 months.
Gotcha.
Just goes out.
Similar order for the next item as well.
5 months.
Hearing. 28.
My Lord has heard this matter, my Lord. In course of hearing, your Lordship asked me to produce one letter which has been referred to in one of the communication. Now, my Lord, that letter, my Lord, I have received that letter. That further, my Lord, substantiate my submission. That letter say that all the payments are made as per the records, as per the actual date they worked. I am just placing this letter, my Lord.
You've given a copy to senior counsel?
Yes, yes.
It is.
So the extra day is not paid?
No, my Lord. Except that Sunday, your Lordships. Now, my Lord, here are 2-3 things are there, my Lord. One thing, your Lordships, there are 22 writ petitioners. Now, my Lord, there is nothing on records, my Lord, what he is claiming on Saturday, Sunday he worked. Nothing. As per our records, my Lord, he never worked. This is one thing. Other thing, my Lord, it is not believable, my Lord, since 2011, they worked for a day and not paid and they remained silent for 13 long years and came, my Lord. That delay, Lordship will see. Thirdly, my lord, he has annexed 2 attendance register of a particular year, 23. Now, one attendance register, one of the writ petitioner, that substantiate my claim. He never signed, my lord, on Saturday, Sunday. Another, of course, signature is there, but there were certain irregularities. Now, Nehu has done away with the attendance register, and they have installed that punching machine. So, at all, my lord, if my learned friend is not satisfied with whatever record I place before my lord, then the only other way out is to file a civil suit, my lord, nothing else. Even if your lordship send it back, my lord, this letter categorically shows we have relied on our records. Now, coming to the memorandum, my lord, where it say, my lord, permission has to be obtained, my lord. That was a, my lord, central government notification meant for, my lord, central government departments, not for Nehu. Nehu, for certain reason, at one point of time, my lord, applied that. And then thereafter, since we switched over to 5 working days, my lord, we have done away with. So my humble submission, my lord, this is not a case, my lord, where your lordship will adjudicate, my lord, cannot be adjudicated, my lord. So my humble submission is liable to be dismissed.
My lord, with great respect to my senior, my lord, the pleading made in para 6, they did not deny that there is many of them work in the essential department. They're not denying in their affidavit.
But the thing is that if they work in such departments, but they're being paid for every day that they work, and if they don't have a scheme in place to give the extra 6 days, what to do?
Well, therefore, actually, they are working throughout 7 days.
Compel them. We only can give that for every day that they work, they be paid their pro rata wages, whatever. That's all.
That is true, but those who are working throughout the week, 7 days, they are not receiving that.
If they work for the week, they should be paid for the week.
They are not paying that. That is one of the grievances. I do admit that, my lord, one category of employees, they are working from Monday to Friday. So plus 1 day, they entitled for 6 days. But those who are involved in the essential departments, there is no break for them.
Then you have to segregate your petition then.
But therefore, there is specific affirmation is therefore. That is one thing. Second is about the memorandum in their own RTI.
You don't have, but then what is your status of employment?
They are daily wages.
What is it known as? Daily wage earners, you know?
And they have been there for the last 20-25 years.
No, that's for daily, the only daily wage.
Well,
you don't have any question of any overtime, nothing.
Yes. And the action of Nehu is clearly violates to the OM, which they have given us through RTI recently. We asked that which rules govern us. Nehu has given. The submission of the respondent that it is not followed by this time is incorrect, as per the record. And those who work in the essential, like hostel, car, electricity, the water supply, there is no holiday for them. And no permanent employee will come to look after them. These people are the one who is starting.
Now, Mr. Sir, what is the performance certificate? What is the performance certificate that you refer to?
Performance certificate, my lord, in the particular cell where they are working, my lord, it is certified by them.
That's all.
That's all.
See, my lord, someone the records.
2011, my lord. 2011, my lord. Case is filed in 20. This is believable, your lord.
But those past claim, that is correct. But it is a recurring cause of action.
That's why I am saying, my lord, this only goes, my lord, the records and other things. If they are not satisfied with my submission, my lord, file a suit.
You file a suit, yes. But that evidence has to be led.
My lord,
and
filing a
has to be
suit.
proved. Whether there's your signature in the attendance sheet or not.
But in one of the attendance sheet we annexed, they are not disputing.
And another attendance sheet, my lord.
So like him, many of them are there.
I don't know. There categorically clearly shows he did not sign. The incumbent did not sign.
Therefore,
so how it is helping them? These are all, my lord, serious disputed question of facts, my lord, which writ court will not go.
Your lordship summoned the attendance sheets of all these
We don't
petitioners.
go all that.
My lord, it will be revealed. It will be revealed. Nehu as a model employer, man, they are exploited. These people are exploited.
We understand, but it's the nature of your engagement that is the thing. Under what the scheme.
But it's OM framed by the Union of India is in my favor. And Nehu did not.
Your grievance deduction.
But the deduction is one part.
There's
and
no
we pray for
deduction in the wages.
Yes. Deduction is one part, but secondly,
deduction.
There is a deduction. These people, my lord, they don't know how to maintain. Now their salary also they transfer through their account, and the Nehu did not disclose what is the exact salary they are providing. It's absolutely controlled by the university. Well, para 6 our repetition is very clear. Well. Those who are working in security cell essential departments. Who did not deny that no, these people are not working essential department. Somebody is working. I would understand. So they are not denying the affidavit also. And the two attendance registers we annexed through RTI. They clearly shows that he is regularly attending throughout the week.
After the deduction was done after 2011, you see, why didn't you come to court or file representation?
My lord, these people, therefore I feel sorry, my lord. These people, even they don't know how to collect the documents also. They have a really hard time for them to collect the documents. They do not know the RTI. So after filing up the writ petition also, they put up some RTI and who has provided the OM that we are following this.
See, the thing is that Mr. Chanesu, all said and done, now this writ petition is fine 23. Right?
Well,
and you're asking for setting aside a notification which is issued in
well, that is 2011. 11. Well.
So how do you expect this court to travel back in time and restore that situation that was there before, at the time notification was before notification was passed? But this is says very categorically, and this also reinforces that you'll be work only in actual, you'll be paid in actual day basis.
But that the paper
so we'll
where
close it, you file the things that we understand your grievance, that they are security people, that they are persons who are working 7 days a week. Maybe but then on the materials we cannot really generate a very definitive order. That's the thing. The thing is that if you have to prove it, you'll have to. There's some other kind of proceeding. They can't go to labor court also.
Labor court? No, labor. I don't know, my lord. Labor court, perhaps.
No, Nehu won't come in industrial.
They will not come back.
University.
The paper I received from my senior also, that 31st March, that is a departure against the OM itself.
OM again, I am saying, my lord, this is meant for the department.
The only thing is that, see, the thing is that if we just, sort of condense it into a very basic thing, is that you are coming here challenging notification issued in 2011, where they said pro rata, you'll be paid with one additional day on the actual days that you work. That's it. So your claim now you have to style your repression in a different way with regard to carving an exception for those those essential services like workers, that they're working 7 days a week, security guards, drivers, maybe electricians, plumbers, whatever.
Yes.
That's the thing.
Water supply.
As the repression stands, sorry, I think it will not address your grievances. You take a call, otherwise you dispose of on that. It's hopelessly barred by delay also.
But if Lordship,
and the scheme that they also implemented earlier, when they put in a 5-day working week, they've done away with that also. So that also we cannot avoid. We have to consider that also.
Well, I
question comes down to where a manifest can issue. The only thing is that if we can't, say that yes, they work for 7 days a week also.
But if Lordship permits me, kind enough,
then we have to prove those documents. We have to bring them here and prove documents. We go to trial court.
If Lordship matter may come up on Friday, let me just concisely prepare the short notes.
No, concisely, there's nothing to prepare also, Mr. Chandrasekhar. What to prepare? It's very clear. Only thing is that you have to, to claim for the work that you've done, number one. That's a different story. And the basic thing that this working against you is that you have come in 23, 12 years after the notification issued.
That is the matter. But if it is
you might say it's a recurring right or
it's a recurring cause. Every month, every 3 months, there is.
Tell them the tentative of the court. You have to seek other remedies, and also maybe we'll give you liberty to file a petition. Considering the workers' matter, with regard to those essential services employees to be,
Well, I pray Lordship may take up on Monday. I'll take instruction with the new paper received from my senior.
Yes.
What is relevant?
The learned Mr. S.N. learned counsel has produced the letter dated
31st March 2011. 2013.
Yes, now very good. Dated 21st March 2011 as per instructions of the court, which however reinforces the impugned notification. Stop. Mr. Alchasna Reso, on this such instruction, please be allowed to.
Yes. Monday, subject to Lordship.
It's on to Monday.
Yeah.
Yes. Yes, so.
29? 29?
This is the case. My entire matter was heard.
Which one?
Entitlement 29, Your Lordship. Entitlement of those financial upgradations.
Who's heard?
Lordship has heard, my lord. That order is there.
Where's Mr. D.K. Datta? Datta, no?
And my learned friend, he wanted time, my lord. Lordship has expressed the mind, he wanted to obtain some instruction. Somehow.
We will obtain material instructions.
Material instruction.
That is why.
Whether to pursue this case, my lord. That was at one point of.
He wants material instructions before the case is put to bed.
Yes. Lordship will see kindly the order dated, my lord. 10/7/25.
We'll dismiss of default. When the matter is called out, none appears for the petitioner. Yes, they've been adjourning it repeatedly. What to do?
1925. He made a submission whether to continue with the case or not to obtain instruction.
1925. He has to still awaited special instructions. What to do? Yes or no? This matter has been substantially heard, and the council was awaiting instructions as to whether to pursue the same or not. However, in the interest of justice, that this matter is done over for 2 weeks. Yes.
Right.
30?
May I please, Your Lordship? This is the case, my lord, regarding appointment of professor in the geology department, which has been challenged by the petitioner. Lordship will recollect. We initially raised the question of maintainability by Nehu as well as by the other private respondents. And my lord, we made all our submission, including filing of the compilations. Now, briefly, if I can refresh my lord's mind, 3 posts in geology departments were advertised, Your Lordships. One was, my lord, open category, one for economically backward, my lord, and one for, my lord, scheduled caste. Now, so far, read petitioner is concerned, my lord, he never applied for the post of.
This is my case. Let me start. This is my case. I'm the petitioner. He can respond.
No, my lord, we have what I am just refreshing your mind. You question the maintainable.
My ears are open. I'm just.
Lordship, my lord.
We'll give you a fair hearing. Don't worry, Mr. T. We are here to do that only. There's a change in counsel.
There were, yes, my lord.
Or were you heard?
I was not heard, my lord. Only they have raised the question of maintainability, but if my lord may kindly peruse the order dated 18/4/2024. The previous counsel who has appeared for the petitioner, this matter was heard, my lord, on maintainability. And my lord has passed an order on hearing the submission. The learned counsel for the parties has appeared that initial application for the respondent number 6 as also the list prepared as interlinked and interconnected, notwithstanding the fact that the respondent number 6 belonged to OBC. In view of the above matter, the same may be taken up on merits. The question of maintainability will still be open for argument by the respondent. So that argument, my lord, they have done. Now I am supposed to respond on it. But my lord,
start afresh.
My lord, I'll start.
What was the question of maintainability?
Yes, my lord. The question of maintainability, as I said, your lordships. Well, give me that compilation.
Yes.
My lord, 3 posts for geology department, post of officers, were advertised, my lord. Out of these 3 posts, my lord, 1 post for open category, 1 post, my lord, reserved for, my lord, economically weaker section.
EWS.
Yes, EWS.
And 1 OBC.
1 for, my lord, OBC. Now, so far the appointment of respondent number 6 is concerned, my lord. He applied against the reserved category of OBC, my lord, and he was selected and appointed as professor in that category. Now, my lord, admittedly, my lord, admitted position is this: writ petitioner applied only for general category. Now, of course, that question came, my lord. Normally, like MPSC elsewhere, my lord. So, my lord, there is no segregation as such. Depending on the merit position, my lord, allotment is done. Now, here in the university is slightly different.
So
Why?
you say that so you say that the petitioner appeared for OBC.
Petition
So
open category.
You are
open
unreserved. Now you say that that's 1 number 6. Who's appearing as number 6? He was appointed against OBC. So that means they can't be at odds. How will he claim his? How will the petitioner claim your post if he's asking unreserved, right? Yes. Exactly. And your opponent is OBC. Exactly. Yeah. Then
Then, my lord, now.
yes.
Then, my lord, applied, my lord. Now, my lord, so far university is concerned, your lordships, selection is governed by a set of rules framed by the UGC.
Yes.
Now, even the selection, my lord, selection, my lord, when it comes to OBC, my lord, the composition of selection committee is different than the composition, my lord, for unreserved. Because there is a requirement, my lord, when a case of a reserve category candidate is taken up, my lord, then there has to be a member, my lord, belonging to that category. So composition of the selection committee changes. So here also, my lord, exactly, when the case of the respondent number 6 was considered, the composition of the selection committee was not same as in the case of general category. So otherwise, your lordship, his case was considered by a different selection committee. The case of writ petitioner was not even there. And what is the proposition of law, my lord? Proposition of law I have pointed out, file a compilation starting from Supreme Court.
Just filed it.
I have filed, my lord.
Those matters when before a different bench.
What my learned senior is not pointing out is this, my lord, that he has also applied for a general post, not only for OBC. That my learned senior is suppressing probably, or he has forgotten.
Let me finish.
Let me finish. This is my petition. Let me start. This is my petition, my lord. The person, respondent number 6, he has applied for general post also, my lord, category also, and also for the OBC. He was screened, my lord, for both in the same committee. Now, what my lord senior is trying to project, that the selection committee or the select committee has, the composition has changed because an OBC category, one representative of the OBC. But it is the same, my lord. It is the same for everyone. The OBC person, my lord, can he show, my lord, there is 2 different notification? There is no different notification. That is why, my lord, let me start, my lord. Then, my lord will get.
See on maintainability first.
Maintainability,
that's the only thing we just are revisiting. See, I'm just Mr. Day, my lord. Just refreshing,
my lord.
That's what last order said, that since matter substantially heard with the bench, send back to his bench. Correct?
Yes, my lord.
So then you shoot that order on. I just wanted to know why it's not maintainable.
No,
why it was
if my lord may
now, the only thing is that if that's a basic thing,
my lord,
that in the end he was not appointed against. He not appointed against a unreserved category. Then what legal injury has been caused to him? Yes, that is one.
His seniority, he become a junior, is now, my lord, he will be considered prior to him, my lord. His seniority is disturbed in the department for the same selection process. That I will satisfy, my lord. I will satisfy. Now, my lord, may kindly produce again, my lord, 18/4/2024 orders, my lord. 18/4/2024, my lord.
No.
18/4/2024.
Yes. Yes.
The matter was heard on maintainability, my lord. I was not a counsel. Senior counsel has argued the matter for the petitioner on maintainability of the writ petition on the point that no relief can be obtained against respondent number 6, who is stated to be an appointed against the quota of OBC, whereas the writ petition is a candidate belong to the unreserved category. On hearing the submission, my lord, that means it was heard, my lord, of the learned counsel for the parties, it appears that the initial application of the respondent number 6 and also the list prepared are interlinked and interconnected, notwithstanding to the fact that the respondent number 6 belongs to the OBC, my lord.
Okay.
There is no doubt about it, my lord.
Okay.
That is
The
why, my lord,
methodology is still not settled.
Is not. It is still
part and parcel of the argument. you have
Yes,
to make.
yes, my lord.
This is 18/4, right?
Yes. So let me just place the facts, my lord. It will be more clear.
Before you start, just 5 minutes.
My lord, my lord.
Yes, now Mr. D, you can start.
My lord. My lord, before I take my lords into the merit of the matter, my lord, I'll just give the background, my lord, how Nehu, my lord, come into existence and what is happening in Nehu.
Came into existence?
Existence, my lord, how it was established, my lord, Nehu.
What importance is that?
No, I will just give the background, my lord. It's like 2 minutes, my lord, it will take. My lord, Nehu, under the Act of Parliament.
My lord, sorry to interject, my lord, with lordship permission. Before my esteemed friend proceeds, my lord. What happened, my lord, earlier case was taken up, extensive hearing was done by the earlier counsel on behalf of petitioner also. And lordship passed an order, matter should be heard on merits along with the maintainability. Thereafter, the case was adjourned, and thereafter, my lord, change of counsel took place. My esteemed colleague took over the matter, and lordship has heard the matter at length on my lord on the 3rd September 2025 on maintainability. On that day, my learned friend never said that it should be heard on merits and maintainability. Lordship has heard the matter online at length, all of 3 of us. And when the lordship asked him to give a reply, my learned colleague took 1 week time. Lordship was gracious enough to give him time. And thereafter, he came for adjournment.
This order was not
lordship
brought
kindly
to me,
see,
my lord, subsequently.
let me just complete. Lordship kindly see, on 10th September, matter was taken up. He came for adjournment. And lordship made it very clear no further adjournment would be allowed. My lord,
Yes, now I remember, yes, because I think the counsel, you're the petitioner. You are appearing here, that's why you wanted time. You asked the counsel to take time, couldn't reply to some query.
No, my lord, it is not like that.
Well, which order
what has
is that?
happened? Let me just.
3rd September 2025 lordship order.
Yes.
And thereafter, that was a day where lordship extensive hearing was done from 3 of us. And on the prayer of my esteemed colleague, lordship was gracious enough to give him time. And matter was taken up on, my lord, 10th September.
Mr. D argued at the time?
Yes, he was there.
No, my lord.
3rd August?
He was there, he was there.
My lord,
3rd September?
3rd September, my learned friend was there.
Yes, 3rd September I was there, my
and
lord.
on his prayer, lordship adjourned the matter.
Yes.
3rd September 2025.
Or 25?
My lord, if I can please, my lord.
Clarify this.
Okay.
My lord, this order was subsequently brought to my notice, my lord, when it was already heard on maintainability. And this honorable court has passed an order, my lord, because on 4th, my lord, 18/4/2024, I was not a counsel.
2024.
I was not a counsel.
Yes.
My lord,
and
let me argue
September.
the matter. They have every right to challenge my maintainability also, my lord, and I will reply to this also, my lord. When my lord has already passed an order that the matter will be heard, both my lord maintainability and on the
Lordship
matter
has
of the
heard
matter.
the matter on maintainability.
10-9.
10-9, my lordship is very clear. It is known that since this matter has been substantially heard, it is expected that on the next date, no further adjournment will be taken.
Correct.
So it is on the prayer of my learned esteemed
Yes.
colleague.
There is no
On
dispute about that, my
maintainability.
lord.
So lordship was actively engaged on the maintainability. And made the travel to another court because of change of roster. And he came back to the...
Anyway, okay.
Let me just
Let us bury that and just you make a submission short.
Not short, but I have to
It's
place
been
everything, my
heard.
lord.
It's been heard substantially. I'll surely remember the article. Yes,
My lord.
on maintainability. Start.
Not on maintainability, my lord. I will go into the merit.
My
and
lord,
also on the
only
maintainability.
before my learned friend starts, my lord, when the question of maintainability remains open, my lord, maintainability has to be heard.
Yes, has
And
to be
that's
heard.
why my lord has taken. And since we have questioned maintainability, my lord, we'll have to start the submission. That's why I said, my lord, we have concluded our submission. Only thing, my lord, on maintainability, I want to refresh my lords.
Yes.
Nothing else.
It's done.
There is a reply now. You already.
I have concluded. He will have to reply on maintainability. The threshold you will have to. I have cited those decisions. Unless you succeed in maintainability, my lord, matter ends there.
Yes.
Threshold. So he will succeed on the maintainability.
My lord, I will reply on the merit also and also in the
reply maintainability first with regard to your application and how you what legal injury is going to cause you.
Yes, my lord.
All this.
First point is this, my lord.
And first time you see, you just limit locus and your legal injury.
My lord.
Has been caused to you. Yes.
The locus
File
is this.
appointment or sponsor. Mr. Nambu, you are paying for whom? UGC.
You can have advance my arguments on
Who are UGC?
no, Lord. I am the private.
Two private respondents.
Open category, unreserved.
Okay.
UGC has not been implemented, my lord. They should have been implemented, but I don't know for what reason my friend has not implemented them on. They was the correct person, my lord, who should have answered this, my lord.
To your detriment.
My lord. We can implement, my lord, now also. If I have the
Too late
instruction.
in the day. Yes.
My lord, maintainability. Without taking my lord to the advertisement, it will be difficult for me to prove my maintainability. I will take, my lord, to the advertisement first, my lord.
Yes.
First, my lord, before I start, my lord, I will just give the background, my lord, what is happening, my lord, in Nehu, and why I am saying this is very important, my lord. My lord, Nehu comes into existence, my lord, or was established under the Act of Parliament in 1973, my lord. There was a draft bill, my lord, which was supposed to be placed under the name of Indira Gandhi University, my lord. For Nehu, it was supposed to be Indira Gandhi University. Then, my lord, the Shillong Student Union, my lord, they came to know about this, and there was an objection raised by them. They say that it should be a local, or it should be Hill State University, my lord. Then, my lord, our late Chief Minister, my lord, Captain Sangma was the Chief Minister. The Student Union, my lord, they have hesitated and all. They was called for meeting, my lord. Then it was brought into notice of the Captain Sangma. Captain Sangma, at that time, Meghalaya Assembly was not in session. Nagaland Assembly was in session, my lord. Captain Sangma has requested the Nagaland Chief Minister at that point of time to pass a resolution in the Assembly, and also by the Mizoram. Mizoram, I am not exactly sure, my lord, whether Mizoram has also passed a resolution or not, that they oppose the name of Indira Gandhi University, my lord. Then, my lord, the correction was made, or the name of Northeast Hill University came into existence, my lord, and it was established. This is the first central university, my lord. This is the third in Northeast and first in as a central university. The first two is, my lord, probably Assam University, Guwahati University and Dibrugarh University, first and second. It is a state university, and central university is Nehu, my lord. Why I have given the background, my lord? From that time of establishment, there was a dispute, my lord, about the name and all. Then subsequently, what happened, my lord? The Nehu is functioning for the upliftment of the higher education of the youths of Northeast Hill, my lord, states. After it was established, my lord, lots of subjects was included, my lord, and it is functioning, my lord. But there are lots of dispute and all this and that. It is probably because of some politics and all. Now, my lord, Nehu is run by a vice chancellor who is the head of the administration, my lord. Not stationed in our state, neither is stationed in the university. The Nehu is running, my lord. So, my lord, can
the point, yes.
No. The cloud is there, my lord, which create doubts, my lord. When a university is run,
stick to your case, yes,
my lord.
Yes.
In this matter, my lord, what happened? An advertisement was floated, my lord, by Nehu for that, which is in page 33, my lord, annexure 2 of the writ petition. Page 33, my lord, annexure 2.
Yes.
Well, this was an employment notice which was published by Nehu, my lord, on 16 March 2022. And the notice says, my lord, online applications are invited from the Indian nationals for filling up the post of professor in various departments in the Northeast Hill University in both the campus at Shillong and Tura, Meghalaya. The last date for receipt of the application is 18/4/2022. But this date was extended, my lord. Extension was given, my lord. We are concerned with only one subject, my lord, that is zoology. That is in page 35, my lord.
Yes.
And for the post of professor.
Yes.
3 posts was advertised, my lord.
Yes.
3 posts was advertised. One is for unreserved, one is for OBC, one is for EWS, my lord. And the specialization they have demanded, which is the requisite qualification which is required for applying for the post, was, my lord, aquatic biology, fishery, number 2, animal physiology, molecular biology, biosystematic animal ecology, entomology. This is the specialization. If you have, my lord, you can apply for this, my lord, post. Number 7, Respondent number 7, I mean, my lord, he doesn't have this qualification, my lord. I will come to that, my lord. Then, my lord, next page, what are the other terms and condition which is required to be complied by the candidature is in page 38, my lord.
Yes.
Serial number 2, my lord. The eligibility criteria of the candidate and other terms and conditions shall be as per the UGC regulation 2018. We are concerned with UGC regulation, my lord.
38 reading
page 38, serial number 2, my lord.
Yes.
The eligibility criteria of the candidate and other terms and conditions shall be as per the UGC regulation 2018, my lord. My lord, I will just pass over a copy of the UGC regulation.
We have it. This is dated 18 July 2018.
Yes, yes, my lord. If my lord has this. The petitioner herein, my lord, is qualified as per the advertisement and he has applied for the post, my lord. Now, many other people also has participated in the process, my lord. I am concerned with respondent number 6 and 7, my lord. Respondent 6 has applied both in general as well as in OBC category, my lord. And respondent number 7, my lord, is for general.
Yes.
Now, if my lord may kindly see the UGC regulation, what is the requirement for the post of professor, my lord? That is on page 60, my lord, of the regulation. Professor, eligibility.
What is professor grade?
Yes, professor. Eligibility A or B. Under A category, my lord. A, my lord, an eminent scholar having a PhD degree in concerned allied relevant discipline and published work of high quality, so and so, my lord. So the first criteria is this, my lord, that he should be a PhD holder, my lord. The second, my lord, and I applied in this category, my lord. Now, my lord, may kindly see page 61, my lord. This, not only with PhD, my lord, there is another criteria which an individual has to fulfill for applying this post, my lord. Serial number 2, my lord. A minimum of 10 years of teaching experience in the university college as assistant professor, associate professor, or research experience at equivalent level at the university, national level institution with evidence of having successfully guided doctorate candidate, my lord. So this is the two criteria which is required, my lord, for applying the post, my lord. Under A, my lord. Now under B, my lord, if my lord comes to B, it says an outstanding professional having a PhD degree in the relevant applied discipline from an academic institution not included in A, my lord. That means, my lord, the person who falls under the category of A cannot apply for in category B, my lord. Industry who are yes,
standing professor, professional.
Yes, my lord.
Not a teacher.
Yes.
Having a PhD in relevant applied discipline from any academic institution, not included above. That means not included in the criteria and above.
Yes,
not included. That means like over and above. Industry has made certain contribution.
Yes.
Now this is for lay people who can apply for professors,
Exactly.
suppose they of eminence
Who are
in other domains,
yes.
right?
Yes.
I mean in other
Yes.
areas.
Yes.
Now there are two.
So
You categorize the two parts.
Yes.
For professor, either you come from a teaching academia,
Or
or you come from
non-teaching.
you're a
You can-
specialist in
Yes.
in your domain. That's all.
That I will clarify, my lord.
Yes,
I will
so-
interpret this.
Yes.
My lord. Now, respondent number 6 has applied category B, my lord.
He's
Whereas he was the staff of NEHU and he doesn't have the requisite qualification of 10 years of experience. That experience starts from the day he obtained a PhD degree. And a PhD
He is non-teaching.
He is a non-teaching, but from
non-teaching,
my lord. He was
can
a
come under
non-teaching. He has to come under B, my lord. But once you are from Nehu, my lord, you cannot.
How do you say that?
That I will substantiate, my lord. I will substantiate. Let me just give a rough, yeah, my lord. That I will.
How long are you going to take?
It will take time, my lord. It will take time.
Another 15 minutes.
Now, what they are saying, outstanding professional means an outstanding professional having a PhD degree in a relevant applied discipline from any academic institution, not including A. Nehu is under A, my lord.
No.
Yes, my lord. Because he
eminent
got
scholar having a PhD degree and is concerned and published with high quality, then B, 10 years teaching experience. Correct?
No.
Yes, so
B is not 10 years experience, my lord.
No.
A.
A2. Means that means you have PhD.
Yes.
That means you are from you're an academic teacher, right?
Yes.
Second is an outstanding professional.
Who is not a teacher.
professional who's not a teacher.
Not a
Yes,
teacher.
he can be anybody.
No, but you cannot be from an education institution. That is what my point is. From any
Central
academic
university.
institution. Yes, you cannot be. I will
Not
substantiate
A
my
above. That means that
a person who is working in an industry may have a PhD degree who can apply for this, my lord. I will substantiate, my lord, this point. Now, my lord, this respondent number 6 has applied in category B and respondent number 7 has applied in A, my lord. Now, what is the qualification which is required, my lord? They have enclosed in their CV, my lord. I will like to take, my lord, to the CV of their affidavit filed by respondent number 6, my lord. That is on page 60. If I may kindly come to page 60 of the affidavit that they have filed, my lord, respondent number 6. Let me kindly see academic qualification, that is in 2.1. 2.1. My lord, may kindly see BSc degree, BSc honors, in which subject, my lord? Botany honors, microbiology and chemistry, my lord. Zoology is not there. Master degree, MSc degree in bioinformation, my lord. That has not been contemplated in the advertisement, my lord. That is my point here, my lord. Now, my lord, may kindly see the specialization. Again, I will take, my lord, to the advertisement which has been floated.
See, will it come relevant, allied? See, it's given here allied, applied. This.
I will, that, my lord, again, as per the
Zoology won't come inside biology?
No, my lord.
Sure?
Yes, my lord.
Okay.
These are all set. That is why, my lord, what I say, my lord, UGC would have been a correct forum party, my lord, to come in. They are not appearing, my lord. They must meet a party. UGC has not appeared.
You made a party here in the petition?
Yes, my lord. Number 5, respondent number 5. On the last occasion, my lord, when they have appeared is 18/4. Miss Pooja Agarwal, she appeared, and subsequently she is not appearing, my lord. They have not even filed an affidavit, whereas their affidavit would have been very pertinent, my lord. And moreover, my lord, the PhD he has obtained in the year 2015, my lord. Am I correct? 2015. He doesn't have, at that point of time, my lord, he doesn't have an experience of 10 years. The minimum qualification which is required, my lord, that you should have a PhD degree, my lord. Then
You have all the qualifications.
I have all the qualification, my lord.
You're the eminent choice, actually.
I cannot say this, my lord, but at least, my lord, a wrong person should have to be
as per
appointed.
your qualifications.
As per, I am qualified.
You are the best qualified.
I am not saying best. I am eligible, my lord, for applying. It is for the selection committee to
Of course,
consider my
I'm saying
application or not.
amongst them, you're saying you're the best
Why I am
qualified.
aggrieved, my lord?
Yes.
A wrong person or person who doesn't have an qualification cannot be appointed or considered, my lord. Why I am saying is this.
We're talking about OBC candidate, correct?
I'm coming to that. Then the gentleman who has applied for OBC, he has also applied for general. Now, why it is maintainable, the rate is maintainable. I have not been only aggrieved by his screening and subsequently appointment. By his appointment, my lord, he was my junior. Now he becomes senior in the department, my lord. Now, before my promotions and all, or any other consideration, my lord, his name will be considered, my lord. Whereas he doesn't have a minimum qualification.
if they had a qualification, what is the harm on writing? Or let them produce the record and show that he is qualified, my lord. The matter ends. Nehu has filed an affidavit. Private respondent has filed an affidavit. They have never said anything, my lord. They are making a statement, but no enclosure, my lord. And in the same ground, my lord, what I was informed, my lord, he was rejected in JNU. He has applied for the same post. He has been rejected, my lord, and he has gone before the court. 10 years of experience. So there is a position, my lord. That is why I am before this honorable court.
No, what rejected by GNU on what grounds?
Same ground.
Apply on the B, he doesn't need professional.
No. I'm saying about he has only 8 years of experience. That is why, after PhD, my lord. That is why he was not considered in JNU. In 22 only he has applied, my lord. Same time, my lord, he has applied.
No, but for this B, you don't need 10 years experience. Where
No,
does it say?
respondent, I'm talking about respondent number 6, my lord. Respondent number 6 is required, my lord. Respondent number 6 falls under A, category A.
Why you apply on the B?
OBC. Just a minute. He is under B, my lord. I'm sorry. He is under B. But, my lord, he is not qualified. He was not having an experience of 10 years, my lord.
10 years not there in B.
No, my lord. Ten years is there, my lord. If the last part of the regulation B. 10 years of experience.
An outstanding professional having a PhD degree in the relevant applied disciplines from any examination. So where is the 10 years here?
The last line, my lord. Supported by the evidence,
Oh, yes, 10 years
documentary evidence,
Okay.
provided he has 10 years experience, my lord.
Okay.
So he doesn't have 10 years. JNU is correctly rejected. For what reason Nehu has accepted, my lord? They have to satisfy this honorable court.
Yes. So where he says had 10 years in this application?
No, they have not said anything, my lord.
No.
But in his application, if my lord may kindly see.
Yes.
He did not mention, my lord.
When this application was made, which year?
22, my lord.
22.
Yes.
So go by now he has 3.1 full-time teaching experience.
Yes.
Full-time research industry. Anyway. Yes, continue.
Yes. So this is 2 points, my lord, where I'm hesitating. That
First, he doesn't have 10 years experience.
He doesn't have 10 years experience.
Yes. Suppose he is not given his appointments cancelled, he will not be appointed in this place.
No, the entire selection process. I'm not challenging only the my lord appointment of respondent number 6 and 7. I'm challenging the entire selection process. The entire selection process is vitiated. For one more reason is this, my lord. That the outstanding, he's saying that he's an outstanding. There is no criteria which has been made out by the academic council for declaring a person as an outstanding personnel, my lord. Yes, it is the law is laid down. Ordinance is there, my lord. They have not followed. My lord, I will just place this Delhi High Court's order.
The first time bring it.
Just I was produced. This is on 20th 11/2020. By way of this present petition, petitioner herein challenged the list dated so and so, wherein candidate has been shortlisted for the post of assistant professor against post number 16, reserved for
2020 now. So
Yes.
now when he applied 22, he complete 10 years.
No, my lord. That is what he has not complied. He has not completed, my lord.
No,
that criteria may be different, my lord. At that point of time, his
2020.
This is 2020, my lord. But
so 10 years, and he applied for news 2 years hence.
In the month of March, my lord. That at that point of time, my lord, he doesn't have 10 years. That is our case, my lord. Let them show, my lord, that he has 10 years.
Yes, you are aware of this, Mr. Changreko? Are you aware of this proceeding before the Delhi High Court? Not aware. And your client.
No way it is pleaded. No way.
There is no plea. And my lord, may kindly see the second page, my lord, of the order.
Yes.
Second page of the order, my lord. Second paragraph.
Yes.
Ms. So-and-so appeared on advance copy of the petition on behalf of the respondent, however, supported the stand of the university. She submitted that the application form as well as the document furnished by the petitioner to the university clearly evidence that the petitioner was holding the post of information officer, which is an administrative post. Petitioner does not fulfill the requisite criteria, as he is not a holder of an academic research position equivalent to that of the assistant professor. So both, my lord, is not that only, my lord, he doesn't have that experience of 10 years. He was not even considered as an outstanding professional, my lord. And this is pending, my lord. This matter is pending before the Delhi High Court.
So till now there has been no appointment?
No, my lord.
It's very unfortunate.
So option B, my lord, it says, my lord, that the candidate must be an outstanding professional, must be from academic institution, not covered under option A, or industry, my lord. That is our point. And must have 10 years experience. This is the interpretation, the clear-cut picture of clause B, my lord. Now what we are saying, my lord, respondent number 6 does not have the requisite qualification under regulation 4.13b, my lord. 4.13b. Now, outstanding, having a PhD degree in the relevant applied discipline from an academic institution not included in A above industry, who has made a significant contribution to the knowledge in the concerned allied relevant discipline, supported by the documentary evidence, provided she has 10 years of experience. As per the RTI, my lord, we have obtained. As per the RTI received by the petitioner from the NEHU, it was informed that the petitioner, that the selection committee
from.
No, I'm just making a note, my lord. That is a note. I will produce the RTI. I'll place the RTI, my lord. RTI is there with us.
It's an affidavit.
RTI. No, my lord. It is an RTI. We'll place this RTI.
No. I mean, we can't just have the one Delhi High Court order coming from here. Then you're reading some RTI application. The matter. How do you expect this court to hear the matter
if required,
completely?
If required, matter will place on record by way of an affidavit.
But you're making submissions. Don't make submissions to RTI. Then, if you rely on it, it has to come in a proper manner. You don't rely on it. Don't submit on it. You submit the maintainability exactly, and you confine your submissions to the grounds that they've raised.
My lord.
Yes.
Here, what I am saying is this: why it is maintainable.
Now you're talking about the selection process.
Yes.
Now you say what legal injury? That's the question. What locus and illegal injury is caused to him? That's all.
Two things, my lord.
Yes.
Respondent number 6 and 7.
Yes.
Now, respondent number 6 has been appointed for the OBC category,
who
was also selected for the general post. He was selected. He was considered in the selection process. Now, by he being my junior, now he has been appointed, my lord, in the OBC. Now, definitely, my lord, he has gone as a professor who is ahead of me, my lord. That will, my lord, vitiate my prospect, my lord, for future, my lord. Because he is my junior, and by this appointment, he has gone up.
No, but then again, he's gone to OBC. He's gone to different highway. Here, different highway.
No, my lord. When it is in the department, my lord, they will consider in the same list, my lord. When it is in the department. Second thing, my lord, if my lord is insisting me to argue on this maintainability, my lord. Respondent number 6, my lord. He was rejected in botany department. In the same advertisement, then how he can be qualified for zoology, my lord? Whereas in botany, my lord, they says the specialization was desirable. Whereas in zoology, my lord, the qualification or the specialization was not desirable. In botany, he was rejected. How he can be accepted for zoology, my lord? Second thing, my lord, if I will just place two things, my lord, for the maintainability. That if the appointment is against the statute or against any rule, my lord, which is governing by the university, my lord, any person who may or may not be aggrieved, my lord, can challenge this. I have a law to place before this honorable court, my lord. There are 10, my lord. We can only see. This is the judgment of our own High Court, my lord. The division bench judgment.
Yes.
There is no quarrel that a proposition laid down by the Supreme Court that a quo warranto is maintainable when the appointment is contrary to the statutory provision. A, the three-judge bench of this, my lord, they have relied on this judgment, where it says that a quo warranto can be issued by this honorable court, my lord. Even if I'm not in that category, my lord. Now, my lord, may kindly see the last paragraph, the last page number 10, my lord. Page number 9, finding that the present petition is bereft of particulars, PIL so and so is dismissed on the ground of maintainability. The PIL is not maintainable in the service matter. However, it is made clear that any appointment is made contrary to the rules, regulation, notification. There is no implement to hesitate by way of PIL for issuance of the writ of quo warranto against such appointment. So my case is this, my lord, that the appointment was totally against the statute.
Devour the rules.
Yes. And more
the pleadings are there in your interpretation?
Yes, ma'am.
Is there?
Is there, my lord. In the rejoinder also they have.
With regard to writ of Corinth also?
Probably that I have to.
There is no quo warranto.
Specifically that quo warranto was not used, my lord. It's difficult to pick up some other thing.
It's very difficult to argue when you haven't drafted that petition.
That is what, my lord. And I was telling to my friend also that it will be difficult for us. But there are two more judgments of the Supreme Court on quo warranto can be issued if the appointment is contrary to the statutes.
Irrespective of the not appearing the pleadings,
yes.
Grounds taken.
Oh no, that my lord. They have not said anything. If I don't give me some time, I will. Then again, we have to go as per the MPDA Acts, my lord, only where pleading is not required. So, two things, my lord, which just come up. This is the respondent number 6 and 7. Wherever they have been appointed in category A or category B, they was not qualified, my lord. And if qualification was there, my learned senior can place the file that yes, this is the qualification with this degree. Now, respondent number 7 is more peculiar, my lord, how he was allowed. It is the screening committee. Now, screening committee, coming back to the screening committee, my lord. Screening committee is headed by Mr. Saha, Professor Saha. And my lord is very much aware, probably, that he was arrested in a bribery case by the CBI. And a petition is pending before my lord.
Okay.
And my learned senior will not dispute with that. I have an FIR copy also. I can place that also, my lord. So
you're saying he took bribe to appoint him?
No, I'm not saying that. But he has.
You're imputing that?
No. I'm not imputing that. Not only I'm saying that. What is the background of Mr. Shah? So now, how they was considered, my lord, when they was not even qualified?
So now just tell the court. Now, when these applications have come, who constitutes the screening committee to screen the applications and put it before the selection committee for
the VC, my lord.
The VC
the
alone
notification was issued, my lord.
Alone, the VC alone is
no, my lord. A notification was issued by the VC, and then my lord, Mr. Shaha. This is my information, my lord. Mr. Shaha was heading the committee of screening committee. That is my information, my lord. Now, nothing on record to show. Mr. San will have the record because I have not access to the record. Who was the chairperson
of the screening committee?
Screening committee, my lord. Is a copy of it. And it was the same committee for all. What my learned senior is trying to project.
So screening committee comes at nation stage before the selection committee is different. Screening committee.
Yes.
Screening committee is the one who screens that whether an order or not, whether you have qualified or not. You see, that's the thing. Whether suppose A, B, C, D, suppose the post of certain posts, and then you have 10 applicants, right? Then the screening committee sees whether these applicants fit the requirements. That's all.
Yes. Now, if I am not fit, my question to myself is this:
then you won't progress. Now you were put up for selection also.
Yeah.
So also 6 and 7.
Yes.
Okay. So screening committee has passed him. That means like once screening committee passed him, he is eligible.
Eligible for.
So you're challenging the screening committee also.
Yes.
You're not challenging the screening committee.
No, I'm not. In the initial stage, the first round of litigation, it was challenged, my lord. I'm not aware. But now, my lord, we are challenging the resolution which has been passed by the executive committee, executive council, my lord. So this is the main fact, my lord, of why respondent number 6 is not eligible. Now respondent number 7. If my lord may kindly see respondent number 7.
Number 7.
Respondent number 7 affidavit, my lord, page 10 is the CV.
Number 10 or 7?
Page number 10, my lord. Respondent number 7 affidavit. Now, my lord, may again consider, my lord, academic qualification, BSc degree, chemistry, botany, zoology, master degree, biotechnology.
One second. One. This is Timir Tripathi.
Yes.
Yes, number 10.
Number 10,
page 10.
Yes, my lord. Academic qualification, 2.5 academic qualification, bachelor degree, BSc, chemistry, botany and zoology, master degree, biotechnology.
Hmm.
The biotechnology is not an allied subject. Moreover, biotechnology, he has applied for the post of zoology, my lord, and he doesn't have a specialization.
Okay.
Now, my lord, may kindly see full-time teaching experience. My lord, may kindly see the next page, page number 11. Full-time teaching experience. He is teaching biomolecular. You may teach anything, my lord, that is irrelevant if you don't have an experience, my lord, for qualification, my lord, for applying a post. And he doesn't have an MSc in zoology itself, my lord. My lord, may kindly see, he is biotechnology. And,
yes, okay.
And the requirement which was supposed to, the requirement was zoology. And where they were supposed to be appointed in the zoology department to teach zoology, my lord, not biotechnology.
We have a lot of publications. Huh?
Yes, publication. That there is no dispute about it.
There's no complication. Very simple. No complication. There's no complication.
Meaning? It doesn't matter.
Qualification. With the qualification.
Yes. You can finish before lunch, Mr. Day, your submissions.
Yes, I will try, my lord. My lord, what he has stated in para, para 9, my lord, page 4.
Para 9. Okay. Yes.
That in response to the advertisement, the answer and respondent fall under under clause 4.1 part 3 category A of the UGC regulation, and as such is eligible for appointment to the post of professor. That the answering respondent number 7 being from the Department of Biochemistry, specialized in biomolecular, and as such he possesses the prerequisite qualification and experience for the post of professor in zoology department, as mentioned in the advertisement employment notice dated so and so. That with regard to the expertise required for teaching MSc zoology syllabus, the same has to be admitted to by the petitioner in the paragraph 11 of the writ petition, where zoology, biotechnology, bioinformation, biochemistry and botany all fall under the discipline, that is School of Life Science. That the answering respondent fulfill the criteria of specialization for the post of professor, since molecular biology is the study of biomoleculars, which happens to be the specialization of the answering respondent. But where in the CV he has mentioned, my lord, the degree, like for example, I have done my BSc chemistry honors, my lord. In the certificate, my lord, they give BSc chemistry honors. Where is the degree, my lord? Let them produce the degree. If the degree is there, my lord, there is no quarrel. My case falls badly, my lord.
Yes, continue.
My lord, regarding this, my lord, I have answered in my rejoinder. My lord, in para 6 of my rejoinder, my lord. That the above made in para 9 and 10 of the affidavit in opposition are vehemently denied by the petitioner, and on the contrary, it is stated there are 4 departments such as zoology established in 1974, botany established in 1974, and biochemistry established in 1980, biotechnology and bioinformation established in 2005, with their respective independent administrative office under the School of Life Science, NEHU. Further, in the advertisement added dated so and so, there was subject specified specialization from zoology syllabus 2015, when there is no question of allied cognate subject to be considered for the post of professor in zoology. It may be noted that the zoology and botany are core subject in the biology, but not multiple disciplinary department, and allied and cognate subject are only meant for a multiple disciplinary department like the biochemistry, biotechnology and bioinformation. Further, the respondent number 7, being from the department of biochemistry, does not possess any specialization which are mandatory as per the advertisement dated 16/3/2022, and as such could not have been considered for the post of professor in the zoology department. Now, what is allied subject, my lord, has to be considered by the academic council. Academic council has nowhere decided, my lord. We file an RTI. The RTI says, my lord, it is a selection committee they have decided. They have no authority. As per the ordinance, my lord, it is the academic council who is supposed to decide, my lord. And the RTI says it is a selection committee. How it can be allowed, my lord, when it is totally against the contradictory against the ordinance of NEHU itself, my lord.
Okay.
Now, my lord, para 7 is very pertinent, my lord, of my rejoinder, that the amendment made in para 11 of the affidavit in opposition are denied by the petitioner, and on the contrary, it is reiterated that respondent number 7 does not have the specialization as mentioned in the advertisement, which was mandatory within the subject domain zoology, and the same are with regard to the specialization as mentioned in MSc Zoology Syllabus 2015. It is further stated that appointment of respondent number 7 to the post of professor in the Department of Zoology is in violation of Statute 13 and 15 of NEHU Statute. As on perusal of the Statute 13 and 15 of NEHU Statute, it is very clear that the Academic Council is the only expert body competent to decide the question of eligibility and question of a candidate, including equivalence of subject. However, in the instant case, the Executive Council NEHU has never placed the same before the Academic Council to decide the question of eligibility and qualification of the candidate. As such, the screening and the selection process carried out by the respondent university is illegal, and the impugn appointment dated so and so appointing the respondent 7 as a professor in the Department of Zoology is bad in law and is liable to be quashed and set aside. So, what I have stated, my lord, in my rejoinder, that they have not a place before the Executive Council. Sorry, my lord, it's the Academic Council. It has been decided by the selection committee. How they can overrule the ordinance, my lord? Statutes of the NEHU. Now, my lord, I would like to take my lord.
Let's see your qualification.
Whose qualification?
Petitioner.
Petitioner qualification. We have enclosed, my lord. My lord, may I come to page 48, my lord. Page 48, my lord. Academic qualification I have mentioned.
Yes.
BSc Honours, Chemistry, Botany, Zoology, English, so. Now, Master degree, my lord, I've done in Zoology, my lord. Cell Physiology and Biochemistry, specialization, my lord. In Master degree in Zoology, my lord, I've done. And my specialization was Cell Physiology, my lord.
And you have the next subject also, just below that.
Which subject in his CV?
Yes, sir. His CV, my CV, that subject is the same.
That subject?
Just below the academic qualification, that subject.
Where is that? That subject?
Just below the PhD, whether qualified UGC, so and so, net subject. Third column.
Net is not relevant, my lord, in this matter.
Neither is MSc, my lord.
Yes. Yes, continue.
Oh, my lord, why respondent number 7 candidature should have been accepted or forwarded by the screening committee is because he is not qualified and he doesn't have an MSc in zoology, my lord, and he doesn't have a specialization. This is my case for respondent number 7, my lord, and who has been appointed for general post in the post of general, my lord, and I have also applied for in the post of general. Now coming back to respondent number 6, my lord.
Yes.
Respondent number 6, who has been appointed, who has applied for.
He's been appointed.
He has been appointed in.
But even 7 has been appointed.
No, my lord. Respondent number 6 and 7 has been appointed.
Yes.
Respondent number 6 has been appointed in OBC category, my lord.
Right.
And respondent number 7 has been appointed in general category.
And EWS?
No one, my lord. There was no such candidates, my lord. So, my lord, respondent number 7, my lord, I address my argument on this, my lord, that he should not have been appointed because he doesn't have the specialization in zoology, my lord. Now coming back to respondent number 6, my lord.
Same thing, you also know specialization in zoology. It's common ground.
10 years experience, my lord, but
so 10 years will not apply now because 2020. So that time it's on different footing. Now it's 22 we applied, right? So anyway.
My lord, yeah, I will come. I will answer to this, my lord. I will just
go on a very like in a what do you call it, in a systematic manner. Now, what are your points you want to put forward, right?
Yes,
so we are the main questions that locus and injury, and so we want to you put 4 points on in a concise and in a systematic manner, so the court also can understand in point form. So we don't end up repeating arguments which you've done earlier.
Respondent number 7, I have pressed my argument, my lord, that he is not qualified.
Okay.
He doesn't have he doesn't fulfill the criteria, and in my lord, may kindly see the rejoinder that I have filed against the Nehu's affidavit, page 3 of my rejoinder. Very small paragraph, my lord, I have mentioned about respondent number 7. My lord, may kindly consider the rejoinder filed by us in page 3 of the rejoinder against the Nehu's affidavit. If I am permitted to read, my page 3, my lord.
Of rejoinder?
Yes, rejoinder against the Nehu's affidavit, my lord.
Rejoinder, not 39. Yes.
I'll just read out, my lord. That the environment made in para 7 of the affidavit in opposition are denied by the petitioner, and on the contrary, it is deteriorated that respondent number 6, MSc in bioinformation and PhD in biotechnology and bioinformation does not fulfill the requisite qualification as required under the UGC regulation 2018, and he does not have the minimum of 10 years of teaching experience in university college as assistant professor or a research experience at an equivalent level at the university national level institution with evidence of having successfully guided doctorate candidates. The respondent number 6, now this is respondent number 7, madam. We don't want to say more on this on respondent number 7, my lord. Now respondent number 6, why the appointment of respondent number 7 is bad in law, my lord? Because there is a violation of UGC regulation, advertisement violation, my lord. They have not fulfilled the criteria of advertisement, breach of NEHU ordinance. These are the 3 points, my lord. Now, number 6, my lord. Coming back to number 6, my lord. What?
The respondent 6 obtains PhD degree on his 2015, non-teaching employee, an information officer, the bioinformatics center.
Yes.
Since they do not have specifications mentioned in the advertisement, divided with the subject domain, so and so. Yes.
Now, they are saying, my lord, respondent number 6 has come under category B.
Now, who is this Dr. Manas Santra?
Manas Santra has also applied for the post, my lord.
And he is a chemistry professor.
He is a chemistry professor. He is in waiting list, my lord.
So, chemistry is allied to zoology.
That is also questionable. But since he is in the waiting list, we are not much interested on him, my lord. We are challenging the entire selection process, my lord. So he will also be included, my lord. I don't know whether he is represented by anyone or not. We have not included him also, my lord, since he is in the waiting list.
Continue, yes.
Well, coming back to respondent number 6, my lord, the 3 points that we are trying to highlight before this honorable court is the violation of UGC regulation. He claimed to come under category B, my lord.
Yes.
But he could not have come. University, college, national institution are excluded, my lord. This is our submission, my lord.
As you are serving NEHU.
As he is serving in NEHU.
Yes, yes.
Second point is this, my lord, he is not an outstanding professional.
Yes.
Why he is not an outstanding professional, my lord? Outstanding professional having a PhD degree in, because outstanding professional who will decide, my lord, and what is the criteria for deciding a person as an outstanding professional, my lord? If my lord may kindly see clause 6V of UGC regulation, my lord, that is on page 76 of the regulation. Page 76, my lord.
Six. In case of selection of outside academic field.
Yes, my lord. 6 selection procedure, my lord. Selection procedure. So, page number 76, my lord. The relevant portion. Clause 5, my lord. 6.5, my lord. Page number 76, my lord. In the case of selection of faculty member who are from outside the academic field, respondent number 6 is from outside the academic field, and are considered under clause 4.1b(3)(b) of this regulation, the university statutory body must lay down clear and transparent criteria and procedures so that only outstanding professionals who can contribute substantially to the university knowledge systems are selected. Now, my lord, who is supposed to
Yes.
formulate the criteria, my lord. It is a statutory body. If we see the website of the Nehru University, my lord, the statutory bodies are included of court, academic council, executive council, board of research committee, and finance committee. But as per the RTI, my lord, which is not on record, my lord, as per the RTI, it is the selection committee. They have said. The selection committee has laid down the criteria. How they can do it, my lord. So selection committee has not only validated the UGC regulation.
The basic criteria.
Criteria.
That means that 2 point whatever. Anyway.
Yes. So my case for respondent number 6 is this, my lord. He has not completed 10 years of research work experience.
When he applied for the post.
At a time for applying the post. Second thing, my lord, there is a violation of clause 10A and FI of UGC regulation in regulation that is on page 94, my lord, of the regulation. So this was a direct recruitment, my lord. My lord got it. Counting of past service for direct recruitment and promotion under CAS. Previous regular service, whether national or international, as assistant professor. So the day he obtained his PhD degree, my lord, he is qualified for assistant professor. He is qualified, my lord. Assistant professor, associate professor, or equivalent in the university, college, national laboratories, or other scientific professional organizations such as so and so should count from the direct recruitment and promotion under CAS of a teacher as assistant professor, associate professor, or any other nomenclature, provided that the essential qualification of the post held were not lower than the qualification prescribed by the UGC for assistant professor. So, my lord, the prescribed norms for person to be qualified for the post of assistant teacher, assistant professor, is that he hold a PhD degree, and he was just an information officer, my lord, and that also of Nehru, my lord. And his service could not have been counted for 10 years, my lord. Now, my lord, may kindly consider clause F, my lord. The previous ad hoc or temporary or contractual service shall be counted for direct recruitment and for promotion, provided that the essential qualification of the post held were not lower than the qualification prescribed by the UGC for assistant professor. So his qualification, he is qualified for assistant professor on the day he has obtained a PhD degree, my lord. So in para 6 of my rejoinder, my lord, against the Nehru's affidavit, I have mentioned the respondent number 6 has obtained his PhD degree only in the year 2015 and is a non-teaching employee as an information officer at the Bioinformatics Center, Nehru. Moreover, the respondent number 6 and 7 do not have the specialization as mentioned in the advertisement, which are mandatory within the subject domain of zoology, my lord. So his service as an informative officer, my lord, could not have been counted for considering this his candidature. Either he has to be A or in B category, my lord.
So on eligibility clause only they will go on saying.
Yes, my lord. And my lord, both this appointment, respondent number 6 and respondent number 7, is against the statute, my lord. It's not that, my lord, which has been, my lord, done not in violation of the statutes, my lord, not in violation of the statute. They have not only violated the statute, my lord, they have violated the terms of the advertisement, and also, my lord, they have violated the ordinance of the NEHU, my lord.
Yes. Now you're seeing again that the power to decide now. So selection committee or academic council?
As per the NEHU's ordinance, my lord, it's academic council.
So selection committee, then when they accept it, that means it's an incompetent body.
No, we're not
to
saying
decide what is allied. Because only question
yes, for deciding allied, my lord.
Allied. See, the thing that all in science stream, whatever, life sciences or whatever.
My lord, may kindly produce this book, my lord. It has been laid down. Something cannot be introduced by the selection committee. It is the academic council, my lord, which has to do it.
This is a very old book, this one.
Yes, it is.
Now developed. This is.
Let them produce a new book, my lord. Let them produce the resolution of the academic council. They have accepted biochemistry, biotechnology.
Okay, fine. We're looking at the. Okay, we find. Okay, you've cast doubt on their eligibility. But again, coming to I think what legal injuries will cause to you?
First, my lord, for respondent number 7, he has been appointed for general category, my lord. If he would have not been appointed, my lord, my prospect would have been there.
How many candidates were there in the fray?
My lord?
Or how many people applied?
9 of them they have applied.
They're all others all eligible also.
They was eligible. No, my lord, according to the instruction of my.
None eligible.
No, my lord. According to the petitioner version, my lord, they are not eligible, my lord.
None is eligible then?
No. 4 or 5 was eligible, my lord, but the remaining was not eligible, and though they have been appointed, my lord. Now, the thing which my learned seniors has to satisfy is honorable court, whether there is
the meat of the matter is your main case is okay. Forget about his eligibility or his locus. Thing is that you are aggrieved with people who don't possess the required qualifications being appointed against a professor post only. Yes. That's the main ground.
Yes.
And I think is that you're saying that okay, the subject on interlinked, that is court. How will we say that it's not interlinked and not related? Now we can't go by that old academic council.
No, my lord. It is related or not, my lord. It is for the.
Now, if first is whether subject related. Number 2 is whether they have the requisite qualification under A and B.
Yes.
Right. Yes. Of that rule.
Yes.
6. Right.
Yes. Yes, my lord.
You want to go around circles. We want to progress.
No.
Now, what's the next point?
These are the points.
Okay, your points that they're not qualified. Now, your what injury? Now you just on the point of legal injury being caused to the petitioner. Suppose we quash the appointments of 6 and 7. Yes. How do he benefit?
Then there will be a fresh selection process, my lord. And I can participate in the fresh selection process.
He's already been rejected, being found unfit. Otherwise, together with the other, if they
no,
there are nine persons who took part in selection. Now 2 have been selected. Correct,
my lord.
Then
2 unqualified.
No. That means he'll fall in the same bracket as those who got rejected. Correct.
Yes.
Then
what I am saying is this, my lord. If in case, my lord, let us visualize, my lord.
Then we have to go see. We have to do a query with regard to exactly to split hairs with regard to the qualifications. Correct.
Yes.
If that's your case.
Yes.
But number 2 again, how will he benefit? Suppose we set aside the appointments.
My lord. Then there will be a fresh selection process. I can participate. And more important thing is this: can this honorable court allow an unqualified person to sit in an office?
Don't question the court. What the court can do, allow, whatever. That's different. We are on a different plane altogether. The court can understand also how we stand to gain and what will happen. Suppose we say, okay, fine, we go into this inquiry, and examination of the qualifications. So that's the only thing.
Fresh selection will be carried out. My prospect will be there. I can again, my lord, participate in the process. I am not over age that I cannot participate. First thing, my lord. Second thing is this, my lord. For respondent number 7, he is been appointed in general category, my lord. If his appointment is quashed, my lord, they can again advertise, my lord, and I can participate.
Don't request for number
No,
6.
no, I'm saying
Number 6 is OBC.
No, OBC also.
These are different.
My lord, I have placed a judgment where, my lord, even if I don't have locus, my lord, I can challenge. But he has applied for both. And, my lord, by screening, allowing him the screening process, my lord, for the general, that itself was illegal, my lord. He was called for both both OBC and for general also, my lord. How he can be allowed when he is not qualified? Why
So they had 2 interviews for him.
There was only 1 interview, my lord.
Then he said that 1 is he applied on the unreserved.
He has applied for both the categories, my lord. That is my submission.
Call for interview for both categories.
Yes. He was considered.
OBC has been OBC, different panel as per submission.
No, that is totally wrong. That is a misleading submission which has been given.
You should not say misleading. We don't looking
Please
into
let
the
me.
record. The way you say
How can I
misleading,
be
don't
access
say
to
like
the record, my lord? It is for my lord to say.
No. The submission was that suppose for OBC category there has to be one interviewer who's from OBC, correct?
My lord, there was only 1 interview, and OBC
all of them
for all of them. I don't think so. That was a submission of my senior that there was 2 interview for the same person. Only thing is this: there was 1 committee for the screening also, and there was 1 selection committee for selection also for all, my lord. It is like a person, either an OBC candidate when he is considered, my lord, a person has to be added in the committee. If there is an OBC candidate and she is there, my lord, she has no saying when a general candidature will be considered. But she is there, my lord. Even when I was interviewed, she was present, my lord. It's not that a case that she left the room. That was not the case, my lord.
So that's your locus, that you say that if she set aside, they will be given a fresh chance.
Yes, my lord.
They've been illegally deprived.
Yes. And respond number 6, my lord, if my lord is saying that since he is an OBC,
yes,
and I have no locus, but for locus, my lord, co-warrant can be issued. Can a person who is not qualified be allowed to hold an office? And that also an education institution where he should guide people, my lord. He himself is not qualified. And his seniority will be affected, my lord. Even if he is OBC. And there is a single, what I have been instructed, my lord, there is a single seniority list, my lord. It is not an OBC different or general different or ST is different, my lord.
Now 7 is important for you only.
But I'm hesitating against 6 also, my lord. My lord may
6
may not consider my submission, but I'm challenging his appointment also, my lord. 6 is that OBC, my lord, candidature. And he is set for the same interview, my lord. And by his appointment, my lord, in the department, he is my senior now. He was my junior. And he is not qualified even, my lord, to become a senior, my lord. And I have hesitated, my lord, and I think I was in a position to place it properly, my lord, that he is not qualified at all, my lord.
So illegal injury is that?
Yes, my lord.
That the selection of unqualified candidates resulted in depriving you.
Depriving me, and moreover, he will be my senior now.
And against number 7 only will be directed.
Sorry, my lord.
Number 7 only will have, and if number 7 can prove his case that he is qualified, that means it's over.
No, I was saying that number 6, he has applied in the OBC category, my lord. Now, by his appointment, he was my junior.
No, that has no that you can't sustain the argument because he's applying against a different category altogether. You can never in your
no, my
you
lord,
can't apply, you can't suppose you can't take his place.
No, my lord, may kindly consider this.
You can't kind of convoluted kind of cause of action that he's suppose he's scheduled tribe category and others scheduled class that
what has fallen from my lord. I understand, my lord. What is my point is this.
You have to show the meeting point.
My lord, may kindly see one thing, my lord.
But
has to
even
appreciate.
appointment OBC will affect him, will cause real injury to him.
Now,
I'll violate his some right violated.
If my lord may kindly allow me, I will substantiate my argument. A person has been screened. There are two processes of appointment. First, my lord, when the advertisement was there, people has participated in the advertisement by showing their qualification. Let it be OBC or general, my lord. By illegally screening a person, allowing him to go in the selection committee, my lord, for general and also for OBC, when he is not even qualified. My point is this: if he was qualified, and probably for some reason he doesn't have a qualifications and all this and that, that is not a case, my lord. The case is this: he is not qualified, and he was also screened for the general post. He has applied for both the posts. Now they have to satisfy this honorable court that a person can apply both the posts at the same time.
Okay.
Because the law says, my lord, a list has to be prepared, and all the select person, my lord, should be in one list. That is a general list. And from there, my lord, they will pick and they will fill up the reserve post, and then they will fill up the.
But because he applied 2 application forms, correct?
Yes, my lord. He has applied 2 application forms, and his generals, for the post of general also, he was screened and he was found to be eligible, which is wrong. He was not qualified.
Anyway, yes.
And subsequently, my lord, when he failed in the general category, my lord, he was appointed in the OBC. But the qualification doesn't change, my lord. The qualification in the general and in OBC is same.
So there was no merit list for the interview.
Yes, my lord.
There was a list prepared for the interview.
Yes, there was a list prepared for the interview.
Where is that?
This side, we have rejoined. My lord, may kindly see my rejoinder. Page 20, my lord. Rejoinder in Nehu's affidavit. Just a minute, my lord. My lord, page 12, I'm sorry, page 12.
No, I'm holding page 12.
Page 12 of my
Yes,
rejoinder.
applicant's physiology.
Yes.
So given this number 7 is unreserved, he applied, and OBC he applied.
Yes.
Choice interview, both places.
It was the same interview.
If he topped the interview, he can't be appointed against the UR post. Suppose against 6 and 7, how is it categorized?
He could have, my lord.
He, as OBC got appointed also. Why? If he is unreserved open.
He could have been appointed in.
That means number 7 beat him. Marks wise.
Yes, in mark wise, probably.
That's all right. So shortlisted unreserved, they were 9.
Yes, my lord.
Yes, we'll continue.
What has?
You just prepare in a systematic way arguments, no, with regard to.
I will.
Tomorrow.
Tomorrow, Your Lordship.
May not be tomorrow, only Wednesday, my lord. Just tomorrow because I have some other thing, my lord. I have an appointment with someone. Wednesday, my lord. Wednesday or Thursday, my lord. Thursday, my lord.
We'll complete it. Yes, let's go for the hearing on
Thursday. Hello.
31.
Please, Your Lordship. As per
where's the correct translation?
Lordship, just we are awaiting that one, my lord.
Court translator पर आए भाई बता रहा हूँ how many pages of translation?
It's only one, 2 pages.
And they've taken time from...
Read it carefully, but actually...
no, shouldn't translate that. Go join them with the correct translation. The original Garo version, selected for the court transfer and output copies. Hey, for office for back, please. Hey, from you all know. Huh? And what the what me? Hey, done. Back, please, lie. Huh? Sorry, I think it's a.
It's okay, man. Let it come next week. No?
Yes.
Where's the original version? Not done. This is very inefficient.
Annexure 5, my lord, of the
rejoinder, my lord.
affidavit in opposition.
Yes, my lord, actually there was no correction. What translated was actually, I have read carefully. It's not.
This is objected to Mr. P.T. Sangma.
Not objected.
Which affidavit of whom?
Objected by the petitioner.
By Mr.
But as far as I have read, gone through, but there is actually, but since they are disputing, but when I read it carefully,
which affidavit?
Yes,
by whom
that is
affidavit?
Affidavit annexure 5, my lord.
By whom? By whom?
private respondent.
Private respondent.
Number 5.
Yes, yes. My affidavit, my lord. That translation, your lordship, actually have read carefully. It is translated by the advocate who was pursuing this matter in the lower court. When I go through it, I find there is nothing wrong in that this one. But actually,
who objected?
He has objected that the translation is wrong.
Where see from affidavit? Which one?
Affidavit in opposition.
Affidavit in opposition
filed by the private respondent number 5. That is page number.
Page number 18, my lord.
18. Page number 18.
Okay.
Page number 18 is the Garo version, my lord. The translated copy is the page 20.
Let me translate again.
Yes. Otherwise, my lord, there are only 3 margins in the report. All the 3 margins in the report is in my favor. Since from 1920.
We're not going to have merits now.
Yes, lordship.
See, though by order date 31/10/2025, this court had directed for transmission of the Annexure 5 Annex to after position of number 5. The same yet to be completed. List after 1 week. Yes.
Lordship. Authorised, Lordship.
Oh, very clear then. So, Nobody take it through. Huh? But it to whoever started there. Nobody would have not found. Section never was for. Huh?
Thirty-two. 32.
Here 32 and 33 are connected. Here 33 is the respondent number 7 has filed the writ petition.
Who's respondent number 7?
1933, I'm paying for confirmation of my service in the sanction post.
And 32, we are asking for what?
I am asking for setting aside his appointment because the appointment was made without advertisement as well as without the template.
We here at 2:15 then. You ready? Yes.
2:15. I have little difficulty, Lordship.
Why?
Lordship, and then next
week.
Next week, Lordship.
What next week?
And,
Then
next week. But next week I'll have some. Can it come up? Can it come after 2 weeks? Madam?
This is like something that happening in the sport is remarkable.
36.
Please, Your Lordship. Lordship,
Yeah.
I'm seeking for some more time on this matter, Your Lordship.
Second half.
No, Your Lordship. I'm seeking for some more time, Lordship.
Time for?
She's praying for an adjournment, Your Lordship.
Oh.
Lordship.
Why? Where's the Thapa, MS Datta? Where are they?
They are
All
not
missing in
available.
action.
They are not available today, Your Lordship.
What's the matter about?
Lordship, my post has been declared as ad hoc after being declared regularized, Lordship.
Is it
It's
covered
a
case?
regularization matter, Your
Regularization.
Lordship. They are saying that they were confirmed previously, so
Where's the lecture we're showing to confirm? 19.
Annexion number 4, Your Lordship,
Action
page
number?
21.
Yes. 19.
Lordship.
And this and page 22?
is the regularization, Your Lordship.
They rise after they rise in 23.
Yes,
after
Your
they
Lordship.
confirm in 19
Yes, Your Lordship.
by the competent authority.
Yes, Your Lordship.
The competent authority director at DHS MI the competent authority regulation.
This was the regularization was done after cabinet approval, Your Lordship.
No, but it was confirmed since 19.
Your Lordship, we are saying that the confirmation is because there was previously, prior to the confirmation, they were serving as ad hoc employees, Your Lordship. So they were merely confirmed in against the regular
And
post, Your
how
Lordship.
can it be confirmed organization?
Let the matter be heard, Your Lordship.
You can't just have so many matters being adjourned indiscriminately. When you want it? Tomorrow?
Lordship, after 2 weeks.
After 2 weeks? It's become a disease, this adjournment. Yeah, after 1 week.
Lordship.
How do you argue it? How many months you practice?
Almost a year, Lordship.
Almost a year. Then good enough. Or you bring Mr. Thapa or one of your senior colleagues argue. Yes.
36 to 40 are connected matters, Your Lordship.
Okay, what to do?
41.
Lordship, I'm appearing on behalf of Mr. Esthapa on this matter, Lordship. I'm seeking for some.
They were doing hearings, so difficult.
Lordship, with regard to the FIR which has been filed by the petitioner against the respondent bank, Lordship, we have taken steps. We have obtained the status report of the investigation.
What is the matter about?
Pertaining to
Debit-
freezing of the
debit
bank
freeze,
account.
Lordship.
Your account has been frozen.
Lordship.
Now it's been defrozen.
No, on.
No, Lordship.
No,
It has
Lordship,
been.
no, Lordship.
No.
They are praying for that, Your Lordship, for
praying for
unfreezing
what?
of the bank account.
You're praying for defreezing also.
No, not me. Lordship.
We
I'm for
are
the
praying,
state.
Lordship.
Who's praying for the bank?
Lordship, the previously a counsel had just approached me and he had just informed that today he will not be available.
Who? Mr. Marpan?
Marpan, yes, Lordship.
Where is he? No one's behalf also.
No, Lordship.
Then let the account be defrozen.
Lordship, we have obtained the copy of the status report
Let's see.
for perusal of your Lordships. Yes, Lordship.
Was your client informed about what happened? That's all. Nothing happened after that.
Nothing has happened.
What's amount frozen? What amount was said to be the fraudulent amount? Difficult. This report has been filed by the Government Council today, indicating this report this dated 3rd of March.
Yes, Your Lordship.
That's the last series report.
Yes, Your Lordship.
You give a fresh series report.
Okay, yes, Your Lordship. We'll do that.
This is already known to you, that means. MS Khatun.
Lordship.
It was already known to you that why it's frozen. Does it appear here? Let us see. Did you get information from the bank?
The counsel for the bank is not here, Lordship.
Yes. This is a matter of this matter day after tomorrow is.
All right.
42. 42.
Please, Your Lordship. Lordship, I pray that this matter may come up after 2 weeks.
Then she will continue other hearing then, which your senior was arguing. I was thinking about other cases, that's why I put the other case at 1:15, stopped hearing the other matter. What to do? What's the matter about? Service matter? This is
Service matter, Your Lordship.
5th round of litigation.
Appointment to the post of Constable, Your Lordship, SF10.
He's been discharged from the case.
Your Lordship.
Honorable discharge or discharge on technicalities. You file affidavit.
Yes, Your Lordship, you filed.
Manchu, Alan.
Your Lordship, here the name of the petitioner was just included in the merit list, Your Lordship. However, he is claiming that he was appointed.
Okay, after 1 week.
Opposed, Your Lordship.
Journals become a disease. I hope next year that the young consuls, especially, you take up the, if your seniors don't argue, you take the file. You have access to the files, right? They don't prevent you from looking at the files, but you lock it up in the chamber and don't let you look at the files. What is the procedure? Simple, small matters, you should all read and argue. You take the opportunity. And if you don't want to argue, you all argue. Mr. Paul Chambers suffering from, they don't do hearings. So juniors should take advantage of that. Court will assist you, don't worry, he will help you. If adverse orders are coming, you won't pass orders. But if the case can be disposed of, very hardworking I've seen. So you should argue also. Correct? Everyone will say, oh, only adjournment lawyers. You don't have that, that label. You say, okay, the young lady, she's a very serious lady and she wants to argue a matter. Right? It's all learning process. So from here, maybe you'll go somewhere else, and maybe work on your own independently. You must, if you get a opportunity, or even try to argue the matters. If you have the brief also. Correct? Okay.